governments at various levels function. The elected reps of the people act on their behalf by enacting laws and overseeing the implementation of policies. This is our chosen path to achieve democracy. This is our chosen path to achieve democracy. Direct and indirect elections and the candidates who are elected are indispensable to our model of representative democracy. This is relevant, Malas, both for granting sanction, heightened scrutiny, destabilizing governments, all those factors come in here. Hence, the Constitution empowers the elected representatives to act on behalf of the people. Consequently, the governor who, despite their constitutional status, is unelected, is vested with limited discretionary powers. The power of the governor to act without the aid and advice of the Council of Ministers of an extraordinary nature. The exercise of such power has ramifications on parliamentary democracy. Hence, the ambit of the exercise of such power by the governor must be calibrated to meet the exigencies of situations where the governor is satisfied on the basis of objective material that there is sufficient cause to warrant the exercise of their extraordinary power. This is the test I would commend very strongly, these 4 lines. Because you're unelected, because you are nominated, that's why. The discretion to call for a floor test is not an unfettered discretion, but one that must be exercised circumspection in accordance with the limits placed. I would say, Malas, his reviewability is less in a floor test because it's kind of within the house and with the governor outside. Your lordship reviewability in a sanction is much more, much more.
Yes.
Your lordship has seen, Malas, the word objective satisfaction already, which I have read to your lordships. Objective material and Malas satisfaction. My lord may just put on the side, which I have not quoted. 193, which says the satisfaction. No, did not get.
Apart from 187 and 188.
Yes. Just note down 193, which this para is saying objective material.
Yes.
Now, your lordship will add objective satisfaction is the phrase used in 193. I'll leave it at that. Lordship will see it. Objective criteria, objective satisfaction, etc. This case is, Malas, in my compilation at page 198.
Yes.
Malas, this compilation is a new one because some of these may not be in the first one.
Oh.
So I have given one. Can I give this, Malas? Lordship will call this case law 3. Kindly add. 4, sorry, case law.
Have you given it now?
Have you given it? Don't say all this starting, just give the relevant page. Why? It's open page.
Subhash Desai.
Same judgment.
All right.
I had not put 193 in the quotation, so this is there. The governor had no objective material on the basis of which he could doubt the confidence of the incumbent government.
Yes.
Sorry. This is page 198.
I'm there. Yes.
The governor had no objective material on the basis of which he could doubt the confidence of the incumbent government. The resolution on which the governor relied did not contain any indication that the MLAs wished to exit from the... Look at Malas, the scrutiny, the way your lordship does it. And this is much less reviewable, according to me, compared to what your lordship is Malas faced with. The communication expressing discontent on the part of some MLAs is not sufficient for the governor to call for a floor test. The governor ought to apply his mind to the communication or any other material. This is the crucial part. Before him to assess whether the government seemed to have lost the confidence. Loss of confidence, your lordship, normally I would imagine
That was a case.
has a lesser Malas reviewability, normally. But it's a good, robust judicial review is what I'm talking about. This is robust and correct. We use the term opinion to mean satisfaction based on objective criteria as to whether he possessed relevant material and not to mean his subjective satisfaction of the governor. Once a government is democratically elected, that's the principle. A democratic government has a right to do wrong. And the right to set right that wrong is not in an unelected governor.
To digress. Now, these are all judgments that you're relying on of Article 356. Article 356, where the role of the governor stands on a very high footing. The responsibility, accountability is more. Now, we are dealing with the threshold under 17A. It is not destabilizing or the government.
No, Malas, it is.
invocation of Article 356.
Grateful for the,
Should this be the
I'm grateful for the,
parameters of consideration?
I'm grateful for the query. Three answers, in fact. It's very
Yes.
grateful. Again, was very relevant. Answer number one, this is our 356 case.
No, the other cases that.
Yeah, so this one is a case where the governor directed a floor test,
Yes,
which Malals would, according to me, considering issues like confidence in the House and majority, are possibly the least reviewable, although I argued successfully in this case, Malals. I would not say it today. But compared to what your lordship is dealing with, your lordship is considering review. This is less reviewable in principle. But the review here is much more direct and robust.
no, true. These
Or
are
lordships would-
matters where review or the action should be on a.
No, Mallas,
higher
no, it's the other way
pedestal.
around, with respect. Your lordship's satisfaction on Mallas, the filter, it's only a statutory provision your lordship is to do.
That's
Mallas.
all. This is
It
what we are
actually-
dealing with the.
Only a statutory provision. Therefore, your lordship's review is-
17A.
Suppose, Mallas, you replace the governor with the secretary to government of India. Why does your lordship review become less because it's the governor?
No, that's not.
He's in no zone.
No.
He's in no non-reviewability zone.
Interpretation of a statute, yes, the examination is the same. But
Materials.
in a case where judgments which concern Article 356,
Mallas,
can we
let me put it like-
paraphrase those things to a
may I
17A
say-
case?
So I have cited three kinds of cases.
Yes, sir.
General power of governor is the first category, Samsher Singh.
Yes.
It is not Mallas, it is a general 163 and all that case, Mallas. Not a case of either 356 or anything else. Second category, one case is a 356 case.
Yes.
Third category is about
This-
floor test.
Floor test. Yes.
Now, I'm asking myself the question. In normal exercise of statutory power by any authority, let us replace the governor with secretary to government of India.
Yes.
Your lordship applies beyond the Tata Cellular test now. Tata Cellular is the old case now.
That is true.
So many new cases have come. Your lordship looks at Wednesbury unreasonableness. What are the tests? Let us look at the test for just 30 seconds. Wednesbury unreasonableness. No material on which you could have come. Taking into account relevant considerations. Failing to take into account relevant considerations. Taking into account irrelevant considerations. Well, it's a case of no reasons, no ratios, etc. Which way it falls is not the point. Your lordship does full review. On the contrary, when Mallas political thicket comes, your lordships does do review. Mallas, the advance of Bommai was to say that your lordship is not shut out. It is not to say that review is Mallas more than normal. It is the other way around. Your lordship were prior to Bommai shut off. Your lordships entered much more into review because of Bommai and these other cases coming later. This case, which I am on 17A, has always been reviewable. I mean, not 17A, but similar. Much more reviewability. So, Mallas, and yet, this is the other part. 17A, let us say, is a public servant who is the deputy secretary. These are all considerations the court must keep in mind. There is 17A, let us say, quay additional secretary. There is 17A, quay secretary to government of India. There is 17A, quay a minister.
To everyone.
And there is, no, Mallas, and there is a 17A, quay chief minister.
Yes.
So, with a full, robust reviewability of a statutory power, your lordship has the heightened consequence that the protective umbrella, if not reviewed properly, can lead to an elected government falling, which does not happen. So, as you go up my ladder being deputy secretary to chief minister, the reviewability becomes more careful, scrutinized, and pointed, because there is the additional disadvantage of governments being toppled by this. Otherwise, why do your lordship create 17A for the higher political part? But there are two parts of 17A. One is the bureaucratic part. One is the political part. The political part has the additional liability that you destabilize. Consider, that's why I said the first para of my submission is that, first para. Your lordship has something running. Your lordship has always wrongs in an elected government. Any passerby walks in and says, I want to criminally prosecute after 23 years. The total span is 23 years, active span is 10 years. Then why have a filter, Mallas? If you have a filter, then why have a filter which is limited review by your lordships? If you have a filter, why have a filter where the governor does not exercise objective criteria? But the governor in a matter like a floor test must have objective criteria, which is more political. I would say with greatest respect, Mallas, that this is a more political thicket than the one I am arguing. Therefore, the conclusion should be the opposite, that your lordship's scrutiny should be more careful and heightened, because Your lordship is not in a classic unreviewable political thicket area. Your lordship is, of course, on the straddles, on the margins of both. But Balas, here it is really, this part is intra-house, where your lordship has 212. Your lordship doesn't go in the house. Of course, the governor is outside the house, but otherwise, Balas, intra-house is protected by 212. So, Balas, your lordship is more cautious here. Lordship is more vigorous in my case, is my humble submission. Now, 17. Then comes MP Balas. The question was governor, etc. Now, come to 8 at page
Yes.
17. This is a very important one.
Yes.
The said decision held. Now, let's first point about MP. Totally misunderstood. Automatic, take the name cabinet, take the name CM, take the name governor. MP says automatically I can go. Actually, the first two paragraphs of MP say the opposite, which I have quoted. Opposite. Undoubtedly, in a matter of grant of sanction to prosecute, the governor is normally required to act on aid and advice. You have made the exception into the rule. Let us look at the rule first. This is the rule. My learned friend started with the exception and not in his discretion. However, an exception may arise, mark the word may, while considering grant of sanction to prosecute as chief minister, where as a matter of propriety, the governor may have to act in his own discretion. Similar would be the situation if the council disables or disentitles itself. Suppose, my lords, there is an allegation that 60% or 50% of the council conspired under 120B. The last sentence will apply. Or my lord finds a group of 3-4 people. Certainly the council has to first consider the grant of sanction. We also presume that a high authority like the council will normally act in a bona fide manner, fairly, honestly. All this is forgotten. It is straight push button, automatic. That's the error. First part. I'm coming to the second part. However, on those rare occasions where on facts the bias becomes apparent. Now mark this sentence for us kindly. This is the
Apparent bias.
Apparent bias. And or the decision is not one of the subconscious or institutional bias. You must be presumptively biased because you are a cabinet. But apparent bias is some demonstration. Some demonstration must be there. And based, I'm sorry, and the decision is shown to be irrational and based on non-consideration of relevant factors, the governor would be right on the facts. First test did not apply in MP. Second test not applied by the governor in my case. That's the only test applied by MP. Now let's just see this. Para 9, 18, page 18, para 9.1. Where on the facts there is a case of apparent bias, this did not arise in the facts of that case. Where the decision of the council was shown to be irrational and based on non-consideration of relevant factors. There are the only two tests. Only. And one did arise. And that one is applied in my case. The decision says, now mark these words for us. Now, this is the context in which I should read M. The decision of the Supreme Court does not lay down any presumptive rule that in all cases where the chief minister or member of the council faces prosecution, there is necessarily an apparent bias. This is a question my lord rightly put to me. However, as third line, as stated above, unless a situation arises as a result whereof the council of ministers disables or disentitles itself, the governor in such matters may not have any role to play. No automatic. Taking a cue from Antule, it is possible to contend that a council may not take a fair and impartial decisions when their chief minister or other members face prosecution. But the doctrine of apparent bias, however, may not be applicable in a case where a collective decision is required to be taken under a statute in relation to former ministers. In a meeting of his council, each member has his own say. There may be different views or opinions, but in a democracy, the opinion of the majority would prevail. Mr. Sorabji has not placed any material to show as to how the council collectively or the members of the council individually were in any manner whatsoever biased. Mr. Sorabji is arguing the opposite point of view. This case, my case, Balas, this is very important. I'm sorry to repeat.
No, we will take it that the Council of Ministers cabinet had suggested something. You admit that governor is empowered to disagree. It is not that he has to follow. He can disagree.
Provided, no,
He can disagree. Caveat, of course. He can disagree. If he can disagree, then why at all we get into all this saying that Council of Ministers and the role of the governor?
I'll tell you.
In the disagreement, whatever you say, he should record reasons for disagreement. That is all.
Little more complicated. Little more.
Yes.
I understand what my lord is saying. My lord is saying the governor can decide.
Yes.
then we just look at the reasons.
No, is it that whatever the
answer-
cabinet says, the governor says yes? That is not the scheme of the
No,
constitution.
Equally,
Ah.
whatever the cabinet says, the governor can always say no is also not the scheme.
Yes.
Now, therefore, when your lordship formulates is thus, the governor can decide. I would like to say that's an incomplete sentence. Let me add the suffix. I would put my proposition as the governor can decide, provided the following 2 or 3 conditions are fulfilled. A, it's a cabinet chief minister or cabinet minister case. That is done. That's the fact. Otherwise, it will not arise. 2 crucial conditions. Can decide if A, there is a demonstration and a prima facie finding of apparent bias. B, if there is shown manifest irrationality. And C, either or both of these must be reflected in the order.
Yes.
This is the correct formulation in my view.
All right.
In my
We'll take it. Now, in MP's case,
Yes.
why did the apex court say it suffered from irrationality?
Yeah, that's coming.
It said because a report was not taken into consideration by the cabinet when they recommended that this should be the action. So the apex court said that that report should have been taken note of and then permitted a prosecution.
And the governor also said so.
Governor had said so.
Governor gave reasons
Yes,
and dealt with it.
yes. No,
I'll check
if
up
you
that
see paragraph 26 onwards of
that's
MP.
exactly quoted coming up. It's
yes,
coming up.
yes.
So therefore, let us just first stop with the principle. The governor can decide subject to at least 3 conditions. Let us get that clear.
All right.
Then your lordship will apply it to the facts of my case. Condition number 1, apparent bias, which must be recorded by my lords as if I am the governor, I will record. Prima facie apparent bias because something, the example is best. Two best examples come to my mind. Let's be very specific. The chief minister saunters into the room and then walks outside. I didn't take part in this. The chief minister's relative is sitting in the council as some other member. Or collectively there are 2 or 3 ministers involved in this so-called allegation. Second, having recorded that is one head. He doesn't record that, doesn't arise. Then he says, even though there is no apparent bias, I find manifest irrationality, which is very simple. Manifest irrationality is a more heightened version of your Tata Cellular.
Yes.
It is what? The best example is what my lord just now said. There are 3 vital documents which Mr. Ravi Kumar as the Council of Ministers did not look at. But they were present and available to him. Then he gave a decision without looking at them.
That's
Then they
irrationality.
came to me, I am the governor. I looked at them and said, look, A, these show culpability. B, more than that, Mr. Ravi Kumar never saw them. Therefore, though Mr. Ravi Kumar's counsel is not biased, it is manifestly irrational.
Irrational.
That is a very simple way of putting it to the best of my ability.
Yes.
That is also a salutary and correct test because your lordship then gets an anchor to decide. Your lordship doesn't lay down law for me or him alone. Your lordship lays down law generally. This becomes the anchor to decide it very easily. And it subjects them to the discipline of your lordship's court is the most important. Either governor is beyond review.
Oh, that's
If
not
he is
the-
not beyond review, which nobody is arguing, then it can't be a cosmetic review, a superficial review, a futile review
by this court.
by this court.
Yes.
Your lordship must have some teeth to catch on, which is this teeth between his report and my judgment. This example is a good example. Now, this is very interesting. Come to the next para. Mr. Sorabji has not placed any material to show as to how the Council of Ministers, collectively or the members of the Council individually, were in any manner whatsoever biased. This is very important for my case. Because I kindly note one more thing. Your lordship is dealing with a very weird case. Your lordship is dealing with the converse of this of MP. MP, they rejected Mr. Sorabji on bias. And in my case, the only ground is bias. I don't want to overstate. Please don't.
Yes.
The only ground is only. In MP, they held irrationality. In my case, the governor doesn't address irrationality. Forget finding. That's as simple as that one. So they are actually mirror images of each other. There is also no authority for the proposition that a bias can be presumed in such a situation. My Lord Malas are very grateful for the question, therefore. It's very important. The real doctrine of likelihood of bias would also not be applicable. So they said we'd applied, if we applied, we'd apply likelihood, not subconscious bias. And likelihood doesn't arise in this case, MP is what the court is saying. The decision was taken collectively by a responsible body in terms of its constitutional functions to repeat only in a case of apparent bias. Now, just pause here. Let us not go further in MP. How was MP cited by the other side and how was MP cited by the governor in his order? Was not MP cited in the order clearly as a case of presumptive bias?
It was.
I'm very grateful.
I mean, it's a matter of record.
It's a matter of record. I mean, it's not that we are saying something, or lordships can't change the language, I can't change the language. This is exactly contrary to the case cited by the governor. This MP is saying no. And we are all reading it and saying yes. Thus, now I'm summarizing MP. I'll come to the other paras of MP very interestingly on the irrationality.
Irrationality. So the bias is over now.
Oh, yes. Thus, so well, because bias was actually what is argued by them also.
Yes, that is.
And by the governor's order, it is argued there. Therefore, it is important to get rid of this part first.
It refers to real likelihood of bias. So even that is not applicable.
Also a very important query in the morning session. 1, bias can be. 2, bias can't be presumptive. 3, bias has to be, if it arises in a case, likelihood of bias. Your Lordship knows very well what likelihood of bias is. Your Lordship deals with every case, well as Nemo Judex itself, as well as all those sub rules, etc. And 4, it must be shown, but I am asking myself one question at the top of page 19.
Yes.
The last 2 lines of 18 and 19 top, not identically my case. Should I be citing MP or should they be citing MP? I don't want to oversimplify or over-exaggerate. Just read those 2 lines. This is my case. Thus, the decision was taken collectively by a responsible body in terms of its constitutional functions. One sentence only. This is what happened here. But you said that a collective decision by a constitutional body is per se presumptively biased by misreading MP. Now, 11.1. The contention, take it out, the judgment. No, the judgment MP. The contention that the decision of the Council of Ministers was tainted was expressly rejected at para 24. The reliance placed on para 17 in the written submission of the opposite side.
Yes.
They adopt the error, Manas. They adopt the error. The decision is not an authority on the point of apparent bias, as the facts in that case did not concern prior approval or sanction of a chief minister. The Honorable Court thus made only a stray observation that in such cases, it may be possible to contend that there is an apparent bias. The next line says, but we are not called upon to decide that. Now, the decision of the court turned down 11.3, not on bias, but because there was an express finding that the decision of the council was ex facie irrational. This is 11.3. And because it failed to consider Lokayukt report, as my lord just pointed out, recommending registration of an offence, which was relevant material. Please note paras 24 to 31. Now, I'll just read this part, then I'll read those paras. Let me finish reading this part. I'm applying it immediately to my case.
Yes.
Applying this to my case, there must be overwhelming material based on which a prima facie case is clearly made out. And despite this, prior approval is refused. That's as simple as that. The cabinet says, don't give sanction. Material says to the contrary. The governor says, this is the material. You are wrong. Then your lordship will not grudge him the power. But he can't just walk in and apply an automatic presumptive test.
There the cabinet had fumbled in MP.
By not looking at this Lokayukt
report.
The observations at 32 of the MP sanction order of the governor dated 16/8 have nothing to do with bias and are rendered in the context of irrationality and arbitrariness, as is plain from the preceding paras 24 to 31. That's the judgment actually, which we have forgotten. We are going on bias. The judgment is not on bias at all. And you are not giving an order on irrationality. Then how are you relying on the judgment? In any event, in the facts of the present case, the order of prior approval does not contain any reason why the decision taken by the council was irrational. Nor is there any basis for such a finding. The governor does not record that there is a certain relevant material. You also put a simple question. Which material does the governor say that the council, of which I was a head not for that meeting, has missed out? Which Lokayukt report? Which report? It doesn't say so. Even assuming without considering there is apparent bias is a ground enabling, there exists no apparent bias in the present case, where the chief minister not only recused himself, not attended the meeting, nor participated in any deliberation. Given that there is no declaration of law in MP, forget the last para. Now, I'll just read that MP for a minute. Which volume is it? It is
And
volume 2, Malas, case law volume 2, earlier one. Relevant at page 339. The page is the bottom of the page. Not marking, while I'm arguing, judgment problem. Give me the marked lines, give me blankings.
page 3.
Is the same volume?
Yes, same.
Huh? This is volume 2.
Yes.
Why are you saying 339?
No, there is no 339.
This 339 is changing here. Changing. Well, volume 4, 231.
Volume 4.
Yes, it's apparently the pages are not matching. Just giving it. No, which case is this? Which case are you showing?
339.
MP at 230 of, is it marked volume 4? Volume 4. Mark it volume 4. Yeah. Don't mark it. This is the latest one. Why don't you mark it?
230 is Nabam Rabia. Earlier to that.
Latest today's volume. Last volume. I
Today's
gave.
volume.
230 is Nabam Rabia?
Yes.
Mr.
This
Soli
is
Farabji has not
210,
placed-
210. In today's volume, MP Special Police is 210.
I'm on the relevant portion, 230.
2?
230 is the relevant portion.
Yes. 230.
So this para your lordship has seen, Malas,
Yes.
already. Mr. Soli
Yes.
Farabji not placed on record how, may I read this? Not placed on record how Council of Ministers collectively or the members of the council individually were in any manner whatsoever bias. There is also no authority for the proposition. Bias can be presumed in such a situation. The real doctrine of likelihood also not be applicable. Right, Malas? This your lordship is read with me.
Yes.
Now, on the same analogy, in the absence of any material brought on record, may not be possible to hold that the action on the part of the council was actuated by malice. So far as plea of malice is concerned, the same must be attributed personally against the person concerned and not collectively. Well, the whole council is malice.
Yes.
My whole council is malice attached in a uniform manner. Even in such a case, the person against whom malice on fact is alleged must be impleaded. However, here arises another question. There are two competing orders. Now, this is where the thing changes. One of the council, another by the governor, one refusing to grant sanction, another granting. The Council of Ministers refused to grant sanction on the premise that there existed no material to show that R4 in each appeal had committed an offence of conspiracy, where the governor in his order was clear of the view that materials did disclose. An FIR was lodged in relation to the commission of the offence. Now, Malas, this is enough, I would say, for your lordship to send any matter back saying council is wrong.
Matter back?
Any matter your lordships can say the council is wrong if para 28 exists.
Yes.
Anybody would say it, Malas. I'll not read it. How is it that the council ignored a Lokayukt report of such detail, Malas? It's as simple as that. And this case is being applied for the other point, for the bias point. This para 28 in my case applies in my favor. I hope.
Yes.
28 is omission of looking at Lokayukt. The omissions of looking at reports are by the governor in my case, today's case. What your lordship said there applies to the governor here. And we'll just see the report of the Lokayukt itself gives the material at the bottom of that page. Your lordship is ignoring everything at the Council of Ministers, and why your lordship not intervene? At the bottom of that page 230, the Lokayukt is quoted. The point is not that they are right or wrong. The point is they should have noticed it, dealt with it. They did not. And then 29, Malas, they say how high the Lokayukt office is.
No, 29, sir.
Yes.
Last 5 lines,
Yes.
30
30?
and 32.
Your lordship is on 30?
30.
Yeah. May I read the last 5 lines? It is now
Last 5 lines of 29.
Yes.
And
Now, while
third-
settle that refusal to take consideration relevant fact or acting on the basis of irrelevant exchanges not germane to the purpose would vitiate an administrative order. In this case, on the material disclosed by reward of Lokayukt, it could not have been concluded that no case was made out. This is their talk about the council.
Yes.
Now,
Now,
it is well settled exercise of administrative power will stand vitiated. There is manifest error of record or the exercise of power is arbitrary. Similarly, if the power has been exercised in the non-consideration or non-application of mind to relevant factors, the exercise of the power will be considered manifestly erroneous.
now 32.
We have, but just 31 for a minute also.
Yes, sir.
31. We have no hesitation to hold that decision was ex facie irrational. This is that manifestly irrational. This is about the council. Exactly these words apply to the governor with great respect. Whereas the decision of the governor was not. That's the competing thing your lordship is looking at. Is your lordship told after so many days of hearing which part of the governor's report tells you, which your lordship is reviewing, that this part of the council of ministers has omitted this? As simple, well, we can all argue all these things. Has your lordship been answered that simple question by the governor? My lord is not sitting as the reviewing authority of the council first. First comes the governor.
No, no, of the governor, yes, correct.
In a situation of this
32,
nature,
32 is what the apex court
the
ruled.
facts of these cases, the governor cannot act in, there would be complete breakdown of the rule of law. We open for governments to refuse. This is in the light of that he must act at his
Yes.
discretion because he finds that the lokayukta is missing. Does it say, Malaj, that governor can act at his discretion after Shamsher Singh downwards without giving a single reason as to what is wrong with the report in which he's acting at his discretion?
So everything boils down to the fact that he is entitled to disagree. The disagreement, yes, should be recorded. What is irrational in the note in the cabinet decision should be recorded. And
That's
a
the
decision should be
crux.
taken.
That's the crux.
That is all.
That's the crux.
Yes.
But Malaj, only with one caveat, even the starting point should be a little cautious. You should not say that first thing is I can jump in. You must look at it cautiously in a harmonious manner and then say, look, I am not for a minute suggesting that your lordship has a case like this, where he has not looked at Lokayukt. I am the governor, I point out Lokayukt, and your lordship says, no, the council is right not to look at the Lokayukt and the governor is wrong. I can never say that. But it's very, well, nothing is not rocket science.
Yes,
It's very
so-
commonsensical. And this also gives the court proper basis for review. It gives the proper test for review also. But Balas, it leads to the interesting conclusion that MP in last sentence on MP Balas is either completely in my favor or completely not applicable on bias
Yes,
or completely misapplied by the governor.
that we'll see.
All these three things.
Yes,
Balas.
the apex court holds it is not a judgment for real likelihood of bias as well. So.
Yeah, well,
yes.
they didn't go into it. They said that, but Balas, that
So the
sentence
submission itself is negative.
negative. And Balas, 1 second, I'm sorry to repeat. One of the reasons negative is the last line of 18.
Yes.
That is the reason it's negative. They are saying, well, actually they don't say it in one sentence, they say it in two different sentences. It is negative, as the lordship says, because they are rejecting the doctrine of presumptive bias.
Yes.
That is the point.
Yes.
That is the take home as far as I am concerned.
Yes. Yes.
That doctrine of presumptive bias is rejected at bottom of 18 and top of 19.
Yes.
They are
Yes.
saying it amounts to this, that you are saying per se there is a cabinet, there is a governor, and there is a chief minister, therefore out you go. Now let us page 21. Now this is the heart of the matter. As I said in the beginning, this is by itself sufficient ground to quash it. Just see the actual exercise of power. Now I am assuming for the minute they're in exceptional. I am never agreeing, Malos, that in the walk-in, walk-out manner in which they are saying. Exceptional cases, I am agreeing. Your lordship is the judge of exceptional, not a judge of Malos, just people coming and telling you that they say you can walk in because there is a 154 paragraph, Justice Krishna Iyer, and the rest of the judgment doesn't repeat it, or because the MP means this. No. But yes, exceptional, where my lord is satisfied, then yes, you can walk in. Even assuming that the governor has in exceptional circumstances to depart from the aid and advice, the power not to be bound does not ipso facto justify the exercise of the power in every case. This is the presumptive argument, where approval under 17A is granted based on the independently exercised discretion of the governor. The validity of the exercise of this power requires two further conditions, which are both conspicuous by their absence. I'm repeating one, though, but I must repeat here with a separate head. Two conditions what I told you, Lordship, must indicate why the advice of the council is manifestly irrational, or at least substantively indicate why he is persuaded not to follow such advice, which in the normal and ordinary course is bound to do. The governor must affirmatively, although not exhaustively, indicate why upon a consideration of materials he has formed a view that inquiry or investigation is warranted. A negative and a positive, or whichever way he wants to put it. Both these tests are not even addressed or applied. Forget your lordship finding and then reviewing. Not applied or addressed. In terms of the decision of the MP, paragraph 15, the power of the governor to differ with the aid and advice is predicated on a finding that the aid and advice is manifestly or ex facie irrational. It is therefore incumbent on the governor to record reasons as to why he is constrained to differ from the aid and advice, as also state the factors that weighed with him in arriving. Now, Vittal asks an interesting case, fellows, on sanction. It's rather well put, fellows. Sanction lifts the bar for prosecution. The grant of sanction is not an idle formality or an acrimonious exercise, but a solemn and sacrosanct act which affords protection to government servants against frivolous prosecution. Sanction is a weapon to ensure discouragement of frivolous and vexatious prosecution, safeguard for the innocent. Next sentence is important. The validity would therefore depend upon the material placed before the sanctioning authority and the fact that all the relevant facts, materials, and evidence have been considered by the sanctioning authority. Consideration implies application of mind. I'm relying on these 5 lines very much, Melis. The order of sanction must ex facie disclose that the sanctioning authority had considered the evidence and other materials placed before it. Then they cite a series of judgments, Melis, and I'll skip Melis to save time. Kranti is cited by me in para 17. And if your lordship goes beyond Karti, the next page, 2010-9 SCC, where the summary I have reproduced with 2 or 3 underlinings at page 24 of my note. In India, the judicial trend has always been to record reasons, even in administrative decisions, if such decisions affect anyone prejudicially. And D, recording of reasons also operates as a valid restraint on any possible arbitrary exercise of judicial or quasi-judicial or even administrative power. And then, Malas, it's a very long list and it's a useful list. So I've read, Malas, A and D, and then read L also for London, Malas, L. Reasons in support of decisions must be cogent, clear, and succinct. A pretense of reasons or rubber stamp reasons. This is another very interesting passage. Had your lordship got the formality of reasons, your lordship is not obliged to accept it. Your lordship is not looking at rubber stamp procedures. Is not to be equated with a valid decision-making process, but your lordship is fortunately at a one stage anterior. There are no reasons to this issue. The reason is why I am not bound. That's all, nothing else. Chairman Mullahs of Kakkar's case at page 26. Now, this passage I picked up because one of this ratiocination is very well defined in this para, rather well put. Come to page 26, 4th line, 5th line. Reasons are live links between the mind of the decision taker to the controversy in question and the decision or conclusion arrived at. Reasons substitute subjectivity by objectivity. The emphasis on recording reasons is that if the decision reveals the inscrutable face of the Sphinx, it can, by its silence, render it virtually impossible for the courts to perform their appellate function or exercise the power of judicial review in adjudging the validity of the decision. How much more will it apply than in this case? Well, I throw a bunch of 1,000 pages at your lordship and say, look, my order is 5 pages. I don't address it, but you'll find something there. And then your lordship looks there, finds a comparative chart. Directly this para, I would say, well, I may be wrong, applies to my case. Right to reason is an indispensable part of a sound judicial system. Another rationale is that the affected party can know why the decision has gone against him. All these are reasons, fellows, why it has gone against him. One of the salutary requirements of natural justice is spelling out the reasons for the order made. In other words, speaking out. Speaking judge, a speaking out. The inscrutable face is ordinarily incongruous with a judicial or quasi-judicial performance. Although the governor is no doubt a high constitutional functionary, this is my submission. The very nature of the power being exercised in this case, and the fact that it's an exceptional power, as he is ordinarily to be bound by the advice of the council, would suggest that the exercise must be accompanied by reasons. The governor's impugned order instead presents the inscrutable face of the Sphinx, and it is impossible to discern from what factors it has arrived at and weighed with disregarding. Now, as your lordship decided Sri Rupa for 17A, yes. I don't think Sri Rupa means what has been said to your lordship it means. It is very clear what it means to me, and I have tried to explain that at 27. 17A casts an obligation of application of mind on the part of, just pause here, Malos. Forget 17, 19, 80, whatever, 287, etc. The concept is basically a lordship should be satisfied of substantive application of mind. Otherwise, lordship is not allowing shadow boxing by saying this is a little less, this is a little more. Substantively. Section makes it clear that no officer shall conduct any inquiry without previous approval. Therefore, the approving authority will have to look into the materials, apply its minds in each of the 3 contingencies, inquiry or investigation. This should go someday. This E and I difference is very, very difficult. And it's, well, sometimes it really becomes a technical one. They should use a different word in the CRPC and this thing. You're arguing about inquiry all the time. Though inquiry and inquiry are often used interchangeably, there exists a difference between the two. Etymologically, the source of both inquiry and inquiry could be the same, as EN is derived from French and IN is from Latin. Inquiry has a formal and official ring to it. Inquiry is informal and can be unofficial. Inquiry would even mean a question to question. Inquiry is a formal investigation. Investigation is search. Now I'm reading the underlined portion. Therefore, the Act casts an obligation of application of mind upon the authority to consider whether approval is sought for an inquiry, or an investigation. It becomes imperative for the authority to apply its mind to what is brought before it, as application of mind is the bedrock of any order that an authority possesses. Failing it should be contrary to the principle of natural justice, as non-application of mind is itself violation of the principle of natural justice. There is no answer to this to say, my order be damned. The application of mind is in the interstices of the mass of 1,000 pages which I have in my office. That's the crux of it. That's the only thing they are falling back on. And that is, a travesty of how I will appeal, how I will react, how I will deal with the order, how your lordship will review it. It's only, a desperate attempt to justify it because they have not done it. So now they've come up with this thing about, papers in the office. Application of mind by an authority is demonstrable. Mark the word demonstrable. Only in the order that the authority makes. Now I'm asking myself, what are we talking about, Wallace? This is my Lord's judgment which was cited against me. What is my Lord? I was not aware, I'm not there in the matter. I have not checked the facts of Shirupa. I can guarantee that Shirupa could not have been a case of a 5-page order with a 1,000-page file. It must have been a better case.
There was nothing in the file, nothing in the order.
Now, Wallace, application
because
of
file
mind
was summoned.
No, but your Lordship puts it very clearly.
Yes.
According to me, the Lordship has to have black and white, which is what your Lordship has done here. See the first line. Cited against me. That's the irony of it. Is demonstrable only in the order that the authority makes. By humble and respectful service, that's the correct view, Wallace. We are not playing games here. For the order to demonstrate application of mind, it must contain the reasons. So your Lordship goes further. First is what is on the order, not what is in my almirah. Second is the reasons in that. As recording of reason and order is the only way that can constitute such application of mind. Then your Lordship gives this very felicity. That's why I quoted the Supreme Court first. Reasons are the links between the mind of decision taker to the controversy and the decision arrived at. Ratiocination, I call it.
Yes.
Reason and application are impregnable. That's a new word, Wallace. Ratiocination, impregnable. No, because this is important, Wallace. This is how administrative law is built up.
It is inseparable.
Public law builds up like this only, Wallace.
It is inseparable.
For an order to sustain the scrutiny of law, be it administrative or quasi, reasons in every circumstance need not be elaborate, no problem. Nevertheless, should bear application of mind. The case at hand and the order impugned will have to be tested on the anvil of the magistrate statute, the intent and the rule of application of mind. If on a coalesce of all the facts that are narrated herein above and the order that is impugned on the anvil of this object and reasons, it would fall foul of the same as the order. Now, let's kindly bear with me here. As the order, except saying there is nothing indicative of the fact that it bears application of mind. Granting approval for setting the criminal law in motion cannot be a frolicsome act as is done by the state in the case at hand, as it does not even bear any semblance of application of mind. As this frolicsome should also be adopted by some other courts.
Playful act.
I go for my frolic of my own. This used to be used in those public servant cases, where it's within the discharge of your duty. So he used to say that in the English cases, he went on a frolic of his own. So
that's the...
Now, I just pause here. My case is actually, in a way, a better example against them. In a way, it sounds like a better example against me, but no. Your Lordship, this case had possibly no reasons. I've not examined the order.
No reasons at all.
In my case, there are all reasons, but for one issue only. And equally for the other issues, 0 reasons.
It contained only those words, checked and found correct.
Checked and found correct. My case is the same for the issue which it had to address is my submission.
No, there are reasons. It's not that it is...
For the issue it had to address. I can write a 100-page order.
But it is not a case where it does not bear even a semblance of reason.
No,
but it is.
That is actually, my Lord is absolutely right. It's an order which has to address Y. Writes 100 pages for X and doesn't address Y. It can't fool a court, it can fool an ordinary person.
That is Wednesbury, taking irrelevant consideration. I'm saying the
100 pages valid and relevant, let me assume. But that is deciding issue A. Today the argument is on issue B. I will be reading the order. Your lordships cannot find a single word on issue B. It's the same case as your lordships. This one, Shirupa. The difference is that you wrote 6 pages on an issue which takes you neither here nor there because it doesn't give you the reason why I am to be sanctioned. But on the issue of why I am to be sanctioned, which is issue B, there is 0. And this was 0 also. In fact, this was more, but I said corrected and found. The governor didn't say that also about me.
That was a case of that kind.
Now, verse 21. The impugned order does not demonstrate any reason, I'm applying it to my case, any reasoned application, especially to the core and crucial aspect. This is the aspect on which there is 0. Kindly see the aspect of how, why, in what manner is there any connection of the petitioner, much less prima facie culpability, to any decision, recommendation, act or event justifying the grant of prior approval. Not a word. It regards the constitution of a committee under an IAS officer and a commission of a retired judge as an acceptance that there is a big ticket scam and does not inspire much confidence. So it uses the other two things. I'm dealing with every reason that is there. There's no other reason. It says that because the commission inquiry is made, that is proof of a big ticket scam, therefore I must give sanction. It doesn't deal with one question my lord put in the hearing also, because I heard it, I was here. My learned friend didn't answer it. How is this petitioner involved?
That is.
No, that's only a question. I mean, your lordship putting questions to me also. I'm just saying, well, this is the heart of the matter. This is despite the fact that by his own earlier letters of 5th of July and 15th of July, the governor himself had drawn the attention of the chief secretary. Now, this is very interesting, Wallace. He says, I have read of a commission inquiry set up by you that itself makes it clear that there is a scam and therefore I give sanction. See the next sentence. The same governor on 5th of July and 15th of July drew the attention of the chief secretary to the matter of alleged site allotment scam at Muda and requested the government to look into the matter and submit a detailed report. Just pause. Suppose the chief secretary had said, sorry, Mr. Governor, I will not have a report to you because you will use the report as an admission of somebody's guilt. Suppose the chief secretary had said so. The chief secretary would have a huge controversy on his hands. So as he has an inquiry, that inquiry becomes the noose around the neck to say, I am now finding culpability. But in both the actions of the chief secretary and the governor, there is no mention of the chief minister role. CM's role, 0. This is despite the fact that, it states that even after such grave allegations being involved in the present matter, and the fact that the materials prima facie support, therefore, now this is the total reason. What is the reason I'll find here, Malas? This is the total reason. Please read it for yourself, Malas, 21.2. Even after such grave allegations being involved, so allegations become a basis of conclusion. And the fact prima facie supports the allegation, therefore the decision taken is irrational. Here again, Malas, he is not giving you any single reason. And most important, the role of my client, the petitioner. I'm myself putting everything which is there against me. The said statement is entirely unreasoned and opaque, especially since all material is fully considered. Then 21.3. The order further says that since the prior approval is sought against the chief minister in the cabinet resolution, therefore it would not inspire confidence to act on the aid and advice. In support of this view, the governor refers to para 32. Now, I have done this fully. Leave it to yourself, your lordships, to consider, is it a fair understanding of MP? The nuance which I pointed out, the meaning of 32, nothing else. Finally, the governor notes that there are 2 versions in relation to the same facts and therefore a neutral, objective and non-partisan investigation. This is very interesting. The 2 versions test is plainly an insufficient basis on which to disregard the aid and advice of the cabinet. As in every case where the cabinet declines prior approval, there would necessarily be 2 versions, as my lord rightly put it, 3, 4 or 5 versions also. Truth has many facets.
Of course.
That is the old saying. What is that Sanskrit saying? Forgetting. It's in Hinduism especially, we say that the path to truth. In other religions, maybe 1 or 2. But we have multiple paths to truth. So therefore, bhakti yoga or karma yoga.
Yes.
So the truth must have many facets. Here are talking only of 2 facets. It was for the governor to point out some manifest irrationality in the version as outlined by the cabinet failed to do. Instead, he treated the complainant's version, a complainant of dubious antecedents, as at par with the considered view of the cabinet after seeking opinion of the Advocate General and decided there were two versions. A neutral inquiry or investigation was called for. This supplies the fallacious test of why not the correct test of why.
Yes.
And if your lordship takes this test, then there is no reason required at all. Further, it is evident from the written submissions filed by the R2 that the decision of 1-8 was placed before the governor on 6th of August. Now kindly see this fellow's sequence in para 22. The governor asked that it be put up before him along with the comparative statements, the chief minister's reply and the cabinet decision. It is then stated that upon reviewing the file along with such comparative statements, certain notes, analysis and points were dictated. I'll put that dictated in inverted commas based on the comparative statement in the documents. On 16th of August, the file was once again put up before the governor along with the dictated notes. It is at that stage that the governor made the impugned order. It is relevant. Now this is one of the bullets. None of the materials placed in this para so-and-so have been placed on record by way of an affidavit. More important. Further and most significantly, if there were notes or analysis points that had been dictated by the governor, it is inexplicable why such analysis would be excluded from the impugned order. Well, my 22.2, I may be wrong, is my most important para on this topic. 22.2. Well, it is never, you dictate a long order in the file and you pass a 6-page order on bias only. Moreover and crucially, while the written submission of the respondent rely heavily on the file notings culminating in the impugned order, the impugned order itself makes no reference to such file notings or the comparative charts, tables, or the notes and analysis which have been dictated and with which the file had again been put up for the governor's approval. If these were indeed the factors that had weighed with the governor would certainly have said that in view of what is set out at flag X or flag Y of the file, it should be Y, not X. He accords sanction, approval. Thus, this is not a case where the impugned order of the governor endorses, accepts, or ingrats into itself a previous file noting. Where the order itself does not do so, it is not open to the respondent to portray the decision as if it is based on such notings. Impugned order refers to the governor having perused the file and to the allegations and having independently submitted report of the same. There is no reference of the charts or the notes or the analysis in the file. The petitioner had submitted a detailed reply, that is my reply, on 3rd of August, raising several legal and factual issues for the consideration of the governor. Apart from meeting point by point the allegations made against me, however, there is not even a whisper with regard to my reply and its consideration, either in the impugned order or in the file notings. The impugned order does not assign a single reason as to why the prior approval is being granted. No reasons as to why the detailed reply is not being accepted. No reasons as to how the petition, complaint, allegations make out a prima facie case against me. Very importantly, no reasons as to what role of the petitioner, while acting as a public servant in discharge of his duties at any stage, in the detailed factual background, is made known either in the impugned order, the file notings, or in the statement of objects or during the course of arguments. This goes to the root of the matter. Then, 22.5, reasons ought to have been assigned, etc. Both the paragon reasons. Now, I'm just dealing with three aspects of 17A, which is, that number one aspect is that, your lordships not equated to Lalita Kumari. Second aspect is the police officer being the first filter.
Yes.
And third aspect is, the impugned order is ultra vires 17A also and 218 also. So these three aspects I am now dealing with.
218 comes at a later stage.
Later stage. Correct. Now, kindly come to this. Two and eight was largely conceded, but I'll just deal with it. I'll come later. Just come to 32 minutes.
Page 32?
Yes, page 32, para 23. The power to grant previous approval is not to be exercised in a manner analogous to the test for registration of an FIR. The submissions proceed on the fundamental erroneous premise that the principles set out in Lalita are relevant for ascertaining the scope of the inquiry. The analogy seeks to draw between registration of an FIR and a grant of approval to inquire or investigate is misdirected, also oblivious of the legislative history behind the introduction. Now, this I am not going to go in detail, but I must let your worship know that the intent could not have been a FIR level inquiry. That's all. I'm just giving a lordship, if whatever is worth is not dealt with by any judgment, it may help your lordship.
In fact, the genesis of why this amendment had to come about sprang only from Lalit Kumar in 2014. The first law commission, I think, is in
No,
2014.
Well, I've dealt with part of that. I've dealt with part of that.
And then it took 4 years to come about.
Because
Because approval was sought to be given to the hands of
Lokayukta.
Lokpal and Lokayukta
and then
for
they,
prosecute, for
and-
approval.
and that was a much higher scrutiny. Only the person was changed
Competent authority comes in.
for the, that's all. But the degree, that's my core point, fellas. The degree was not reduced is my submission. That's the only point. Your lordship will summarize it now, fellas. The initial idea was a proper filter and safeguard. That remained the idea. The power was taken from him and given to me.
Yes, it was initially envisaged to be given to Lokayukta or
Fine.
Lokpal.
He is the local, I am the authority. It came
Now
to
it
me.
is to the competent authority.
But in that process of transfer from him to me, the diminishing of the power to the extent it did not happen.
No,
is
the
my-
provision remained the same, or the idea remained the same.
So
It
that's
is only the person who grants
I
approval.
am very grateful.
change.
That's the crux of my submission. The idea is my
The
point.
Whatever protective
Idea
filter,
remained the same.
protective filter that was envisaged in 2014 remained the same.
And
Yes.
the degree and quantum of that remained the same. The person excising it changed.
It took
That's the
4
one-
years to come into this form.
That because of all these committees and
Yes,
back and forth.
yes.
This is a delightful phrase for committees, man. It's a wag. Your lordship will pardon me. It is not meant for any committee. But what is it? A wag generally commented that a committee is usually a group of the unfit, appointed by the unwilling to do the unnecessary. So whereas these delays happen because you want to whereas also take off the time. Well, it's 24.1. The Prevention of Corruption Amendment Bill was introduced, did not contain any 17A. Then 24.2. It was first considered by the Rajya Sabha Standing Committee in its 69th report.
No, all that I'll go through.
Then,
Sorry.
well, I'm not reading it.
Yes,
Then it was brought in 24.3. Then that bill went to the Law Commission
yes.
in February 2015. Now, this just see the middle, Malas.
Hmm.
It is clear that the previous approval would be granted by Lokpal or Lokayukt and would be conveyed by an order under Chapter 7. Now, this Chapter 7 outlines the procedure for a robust and elaborate procedure, including calling for explanation. Therefore, from a mere perusal, it is clear that it is my submission. From very inception, the amendment proposing 17A as an additional entry checkpoint protective filter, entry checkpoint protective filter, was contemplated as substantive protection and nowhere close to the standard for registration of FIR. That's my proposition, but that's my lordship's consideration. Then went to select committee, skip that, come to 25. No, I'm sorry, 24.5 is very important. I'm very sorry. The select committee proposed a further amendment where the power to grant approval was given to the appropriate government and not to the Lokpal. Thus, a change was made as to who would exercise this power. But it is clear the intent was always that the protective filter would be a substantive protection. Well, also, it's very clear, Manoj, I happened to chair this committee in 2011 when the Lokpal bill was passed. Well, we piloted the Lokpal bill.
Yes,
Now, when the Lokpal, delay is inevitable. That was the main reason for this transfer actually.
yes, yes.
Because
To
the
the competent
lordship
authority.
give it to the Lokpal and give it to a competent authority is a vast difference of time. That's all. It is not that you are making the power less. It is just that you make it faster. That's really the bottom line thing. But anyway, this unfortunately not decided by any case. Then Malus, Shirupa at page 34. However,
That's a coordinate bench judgment where 17 and 19 are considered differently, and it is said that 17 need not bear that much of an application of mind like 19. That's a
Right.
coordinate bench judgment.
right.
Yes.
So therefore, Malus,
Which distinguishes the judgment that I had rendered.
but Malus, I am relying on a lordship judgment. I am
Yes,
not
yes.
distinguishing it.
Yes.
I am adding to it with
Yes.
this para and underlining what I'm relying on this one also.
Yes.
I have no contradiction in my mind. They have the ones who argued, may have argued differently. They thought that Shirupa is against me. I demonstrated that part of Shirupa, lordship was judged. Now this one, just see what I'm relying on.
Yes.
Middle of page 34. In a sense, a public servant is placed on a pedestal and treated differently as compared to a citizen against whom an allegation of an offense is thrown. The law thus grants an extraordinary layer of protection.
Hmm.
This is the idea.
Yes.
Then 35. I'm not trying to avoid anything. I've quoted it, but I'm just reading
Yes,
faster
yes.
too. Has some credible evidence on the basis of which he forms an opinion that an investigation is warranted. Who is he, Malas? This he here is the police officer. This he at 35 credible evidence on the basis of which he forms an opinion that an investigation is going
Police officer is what you are trying to say.
Then,
Yes.
Manoj. No, the whole para, just give me a minute. Let's come to para 30 at page
Hmm.
34 bottom.
Yes.
It is therefore not necessary there should be a clear incriminating evidence with the IO.
At the stage of him seeking
At the
approval
stage of him
under
seeking
17A.
prior, all that is required in the provision of the Act is that the IO has some credible evidence on the basis of which he forms an opinion. This part is clearly IO, Manoj. He gives me the information, I am the IO, I form an opinion, then I seek approval. There are 4 steps or 3 steps. Information, formation of opinion, seeking of approval. As a consequence, the state government would be required to only consider the opinion that is formed by the investigating officer. Why is the Lordship saying all this? And the material that he possesses while considering the request for approval. Since the public servant is yet to be investigated, the question of considering an India, I'll skip that. 34, next para. It is also clear from the wording of section 17A. The state government is not required to exhaustively and meticulously consider all the material available with the investigating officer at the time he seeks approval. It is only required to
This is
examine.
where it is different from what I have said.
Correct.
It need not apply its mind is what is said here.
Well, it's, I see the difference in emphasis, but I don't think it would be right to say that your lordships is wrong in saying application of mind. That would be, well, say, something which will possibly not stand the test of law, is my submission. And this, even though it's worded differently, should not be read to mean that application of mind is so diminished as to be a formal administrative entry in the register.
Yes, that is.
That is the way I would look at it, because according to me, 17A is somewhere between 19, etc. and Lalita Kumari. That is the correct way to look at it. Please don't reduce it to just a Lalita Kumari level. Please don't elevate it to a 19 level.
Yes.
Because that's a
exactly
fair,
the
it's a
point,
fair
yes.
way of looking at it. Otherwise, Manoj, why have all these select committees, parliamentary standing committees, law commission? I mean, was it the intention, Manoj, to make this kind of a provision? You already had Lalita Kumari, it would have taken 2 sentences to say we apply the Supreme Court, Lalita Kumari, we are doing this. Manoj, your lordships is being asked to dilute it to a level which is not fair on the legislative history of 17A. It is not borne out, certainly not by my Lord's judgment, but also not by this judgment, which should be read in harmony with the Lordship judgment, instead of deliberately saying we must drive a coach and four between the two.
Because para 34, if you see at page 35,
Yes, sir.
that is what is not required to exhaustively metically consider all material available within
It is put in that
at the
way.
time of seeking approval.
And it is only required to examine and consider the opinion formed. Now, I would, if that is the argument of the other side, I would say maybe when he gives it to approval, he may not put everything. But in his own formation of opinion, the lordship tests remain. If I am the IO, my formation of opinion must bear a full application of mind. Maybe, Manoj, when I reproduce it for approval, this judgment can be read otherwise. Just come to 36, Manoj.
Yes. 36 itself, para 36 at 36.
The grant of sanction to prosecute and the grant of approval to investigate are two very different concepts and would be governed by completely different parameters. At the stage of seeking sanction to prosecute, the IO would have completed the investigation, would also have collected material which his opinion would prove that the public servant is guilty of the offense alleged against him. In other words, at the stage of seeking sanction to prosecute, the IO is well armed and certain that there is material to establish the guilt. In respect to according an approval to investigate, obviously the situation will be completely different. Since at that juncture, the IO would not normally have any incriminating material, only possess credible information about the commission of an offense. It is this credible information that is required to be considered and analyzed by the government. It is thus clear that the parameters that govern the according of approval should be completely different, and the government would have a much wider discretion while considering the request of the IO. I am on a different point, Bharat. I am not on this point. I am not on this perceived collision between your lordship's wording and this wording. I am on a totally different point. Who is all this? It is not a direct lateral entry by somebody without the police officer IO, whether he does this much application of mind or this much. It is he who does it, not a lateral entry versus bypassing him or overriding him. That's my argument. Page 37, para 46. Law accepts there be different standards for granting approval to investigate or granting of a sanction. One cannot be equated with the other. To put it differently, the parameters that are to be applied to investigate a public servant are not as stringent as the parameters which provide for granting sanctions.
This is what is,
No, that's true. That
the
there is
application of mind varies from 17 to 19.
let us, for my purposes, accept that.
Yes.
I am saying, Malas, don't reduce it to the vanishing point of Lalita Kumari. Don't elevate it to that side.
19.
And secondly, it still has the police officer. This lateral entry, I'm not agreeing to. I'm trying to build up that argument. That's the second part of my argument. Just come to the
So
bottom
it
of
is
this.
only the police officer who can seek approval.
Start this whole thing. Because Malas, he's supposed to be the custodian, sorry.
All right.
And without a statutory custodian, it is not that Malas, he's the best custodian, but he's a statutory custodian, he's a persona designata.
Now, in a private complaint, how will it work?
It must go through this first.
No. How can it go? They go to the police first.
Yes. No, because it's not the private complaint who determines this.
No, no, no.
will
Straight away,
determine-
200 will not spring.
Yes.
154.1, they will go to a police station. Jurisdictional police, they will not register. Then a higher officer under 154.3. Then they approach 200. In 200, where is the police officer unless it is referred to investigation?
Now, Malas, two things. The number one answer. The test is based not on private or public complaint. The test is based who's the accused. That's
No, no,
one way.
accused may be anybody.
No, public servant.
Of course,
When-
if it is
when-
Prevention of Corruption Act, 17A comes only because it is public servant.
So first and foremost, this is a safeguard for a limited class of people.
True, it is public servant. Now, in this functioning, the police station, yes, police officer should seek approval, no doubt about it. In a private complaint where police officer is not involved, police officer comes into picture only when 156.3 or 175 reference happens. Reference happens for what? For registration of a crime. If registration of crime already happens, where is the question of approval?
There, Malas,
That is why that
there, Malas, either
the police officer only should seek is a little
I
difficult to.
understand, but there, if that is the case in a private, but then the private complaint example can't take over all the non-private complaint cases. That's answer number one. The
No.
Lordship will not read it
In
in
a
a way.
non-private complaint, obviously it will happen by a police officer.
No, but then your
Approval will be
Lordship,
sought by a police
then
officer.
your Lordship, even in that category, is giving the possibility that it can be somebody else altogether. That can't be the law. But second answer, Malas, then in that case, the magistrate will have to iron out the problem.
No. That is why in that judgment, what I wrote was, in a private complaint, you are taking away the 17A approval and directly getting the crime registered. That protective filter goes away. It is rendered ocious or rendered redundant.
Yes.
For that reason, whoever approaches the magistrate who would wanting to register a crime against a public servant, it is his responsibility to get an approval. Without the approval, the crime cannot, no reference can be made under 156.3 is what I have said. Their police officer comes only after 156.3.
What my Lord is
How
saying is that
do you harmonize the two now?
my Lord is right, that the Act has not thought of this problem. They should have, but Malas, 156.3, should it not be coming after 17A stage, Malas?
Yes, that is what I have written. That is exactly what I have written.
So, Malas,
Kindly consider this. If this interpretation is given, will the protection given under 17 years still continue to be available to a public servant? If you allow anybody and everybody to walk in and seek.
No. That is exactly why 17A is made applicable to private complaints also. See, now imagine a hypothetical circumstance that 17A, one complaint is registered before the Lokayukta. The Lokayukta police will seek approval of the competent authority under 17A and try to register FIR, begin investigation. Now that procedure will be obviated. Ultimately, what the complainants would want, registration of a crime against a public servant. Now 17A is a bar. If private complaint is a stranger or citizen, any criminal law can be set into motion by anybody. So they go before the magistrate, register a complaint under under section 200 for various offences, including PC Act. Now straight away reference is made for it is referred to the Lokayukta, FIR is registered, investigation commences. Where is 17A? The very purpose of 17A is lost. That is the reason private complaint also.
The other, this is of course, well, there's a, if I may say, the casus omissus possibly in the act also.
Casus omissus, yes.
That's not your lordship's problem, that's not my problem. that's
Yes,
your
that is the
problem.
legislature, that's the,
Well, is it possible to say that the 156(3) must come and then you go through 17A after that? Because 156(3) brings in the magistrate. And then well as the private complaint goes on, but then before you proceed further, the 17A approval comes. That's another way of looking at it. I'm just thinking.
that can also be done. But prior to beginning of investigation against a public servant, 17A compliance is mandatory. That is what exactly I've said. Because what used to happen in so many cases is, they don't go before the lokaयुkta, they don't go before the police.
You go
Straight
direct-
away register a private complaint. And once it is referred for investigation, the police have no jurisdiction except to register the crime.
Nullifying 17A.
So defying 17A.
Fact, question of locus did not arise either in Dr.
No,
Ashok.
locus is alien to criminal law, sir.
Apply under
A
17.
locus to apply, locus to apply is,
Arise either in Dr.
No,
Ashok.
locus to apply would, locus would become applicable to the person who wants the complaint to be registered. Now, the police officer wants to investigate, he will seek, that is under the act. Now, the complainant wants a private complaint to be registered against a public servant for offences under the PC Act, he will seek.
So there is a problem, brother. Only thing I can think of is that there is a 156(3) going to the magistrate and some procedure of 17A follows that. That's one way of looking at it, Wallace, but.
We'll see, we'll try to harmonize in this case.
Anyway, your lordship is good, Wallace, because
Yes.
if 156(3) goes first and 17A follows, your lordship is having fidelity to both. That's what I was just trying to think out. But there may be some other problem I'm not able to think out immediately, Wallace.
No, why I wrote that order was, I'm trying to, otherwise 17A becomes.
The lordship may consider this, that your lordships should preserve the primary filter of the police officer. One way of preserving it is to have the 17A cases in a private complaint go through the filter, of course, as it does through a 156(3), followed by the requirement to get a 17A.
Well, accept that. Now, in a given case, 17A approval will be sought. For what? It may not proceed further.
No, but Wallace, your lordship is only concerned with the approval being sought and going through a police officer's filter. It may
That's
not
what,
be
whether
given
it is the
except when
police officer or the person who sets the criminal law into motion.
Wallace, it can be with 156(3), there is some greater harmony as I see it here, Wallace. Any magistrate may order an investigation in
Yes.
156(3).
Order an investigation.
But Wallace, if 17A has to have meaning, then why
No,
can't
now against a public servant also, a magistrate can order investigation.
But then, exactly. But then, because he's a public servant.
17A should be there.
Exactly.
That's exactly what I've written.
But Wallace, after the entry of 156(3),
29.5.
Wallace, I have tried to answer it somewhere lower down, Wallace, but let me just read through it. These are the only two answers, Wallace. The harmony can be that your lordship does not render a 17A to be
No,
diluted.
the language in 17A is no police officer shall commence inquiry or investigation. Fair enough.
All three covered, all three are covered.
All three, no problem. No police officer can commence without prior approval under this provision by the competent authority.
Technical sense, the magistrate.
Who
comes-
seeks the approval is not there in the statute.
That is a separate matter, Wallace, whether locus is not there, criminal law has locus or not, all that is separate. My point is, whoever it is, let's say assume a stranger is there. Your lordship gives a definitive role to the police officer. The first port of call is a magistrate who's not a police officer. He initiates or allows their filter of 156(3). The second port of call must be a 17A police officer. And then, Wallace, that man, if we say no,
Now,
then the
150
locus ends. That
Now 156(3), magistrate refers. Will the police officer who has been directed to conduct investigation wait for an approval from the competent authority?
No, that's then one of the answer is clear. Once your lordship accepts that, answer is yes, he has to.
Ah,
Otherwise,
that
what's
is
the point of
why-
having 17A? Then your
That
lordship-
that is why, to obviate that procedure of once referring the matter for investigation and registering the crime, so taking 17A approval for conduct of investigation. If a prior approval is already there, magistrate will refer it and the investigation will commence immediately.
that will balance.
That is what Is what.
I understand, Manoj, your lordship may consider harmonizing in this way because that
is-
means that the primary port of call of the police officer is ended or diluted. That is my problem. I'm trying to harmonize that part. In this other model I am giving your lordship, which is not fully thought out, maybe I can give a supplementary one-page note after thinking it out. It appears prima facie that your lordship does not violate any of the provisions of the statute.
That's
Because
all.
the outsider chap, Malas, goes to the magistrate, he gets some order.
Yes.
Then, Malas, it must fully satisfy the police officer who will say no. That's the end of the story as far as he's concerned at that point.
No,
At
he has
that
no
point.
jurisdiction to say no once the magistrate refers the matter for investigation. The investigating agency cannot say, I will not investigate.
That's the point.
That is why that protective layer should
Right, no,
spring
my lord,
prior
right.
to the complaint.
Therefore, your lordship judgment will have to say that the 156.3 order cannot violate a 17A order. Your lordship will have to say that a 156.3 order must then thereafter.
Cannot violate a 17A order.
No, not
True.
cannot violate. Must not, Malas, override a 17A order coming later. The 153 will say, I'm referring it, but this part will be done first, 17A. PCA. Because this was, in fact, was the more
PC
we
Act, of
discuss
course,
it,
yes.
it's becoming partly clearer. Your lordship is having a limited class. It is not except outside the PC Act and public servant. For that limited class, suppose the magistrate says, he will not say it generally, he'll only say it under your lordship's orders. Otherwise, High Court has to lay down the law. That, look, I am issuing a direction, I'm initiating this investigation, but where 17A is required, it will proceed further only after 17A is given or not given.
So now magistrate refers under 156.3.
But then comes
The
17A.
jurisdictional police or the locaयुct at whom it is referred, he may have to wait for 2 months, 3 months for approval and then begin.
That is one way of looking at it.
And then begin. Is it not that if the approval is already there
Ah.
and a private complaint is preferred, reference be made prior to approval, is not a better circumstance?
Then your lordship is bypass the police
No,
officer's
we
domain.
are only permitting police officer only to investigate. Nobody else is investigating. After reference, only the jurisdictional police or the locaयुct will investigate. But he will investigate only after the approval is there under 17A.
I understand. There's a slight issue there. Initiation is not by the police officer in your lordship's formulation.
Yes.
Initiation is by the police officer under the magistrate rule. That's the only difference. If your lordship finds that the initiation power is preserved in my model, I mean, in case it's just loud thinking about it because there's nothing so clear here. In case the initiation power, which is clearly borne out by the language of 17A, I have no doubt that 17A language bears that out
No
also.
problem. Yes.
It is not, I mean, your lordship can interpret differently, but it does not rule it out. If that power is borne out, then it is possible to harmonize that initiation power under 17A with the private complaint and public servant character through 156.3. It will require some obvious harmonization, but that's a possible view. Anyway, I leave that. I come to 38. Sections, this is only an alternative argument in the sense that it's not, it's not dispositive either way of any of our cases. 17A places a public servant on a different footing and grants to such public extraordinary layer of protection. This extraordinary layer is set by our lordships, not by me, not by. The protection, the pre-investigation may not be as stringent as stage of sanction. I've already said.
That is by the coordinate bench.
Yeah, I mean,
Yes,
by the
yes.
court, not by, not a submission.
Yes.
Then 26.2 is neither as weak as Lalita nor as high as sanction.
Yes, that's
And
fine.
26.3, not be necessary to have incriminating material to show conclusively, but it's still necessary for credible information. Then while I'm trying to harmonize to the extent I can. While a microscopic examination or meticulous consideration may not be needed, cryptic orders would nevertheless fail to meet the requisite test. In this case, at para 51, the court concluded a clear opinion had been formed by the investigating officer that he suspected the commission of an offence. Subsequently, on considering the material, the state government came to the same view. In the present case, certain important factors must be borne out. I'm applying it here. There is no view at all formed by the IO. Now, this is what I want. This is my problem. There should be, otherwise, the lordship is opening the floodgates. And my word friendly governor was not intended as a mark of insult. I'm talking of a constitutional lacuna. If this 27.1 is accepted by your lordships against me, it's my submission, but if it is accepted against me, then your lordship is allowing this friendly governor or a opposite political color state government. And whereas all these concepts of governor above politics and neutrality is now gone. Let's not live in fictions. Whereas we have governors, we have got governors who are resigning from governorship and fighting elections.
No, now to seek.
There is no such thing.
Correct. No, now Now, if your submission is that the investigating officer only should seek sanction, approval from the hands of the competent authority, who is the investigating officer here to seek approval? There is no investigation now,
Then, Malas,
not yet commenced,
no, that he will
not
have
yet
right-
commenced.
That's a procedural matter. Malas. Somebody will, if somebody goes with a complaint,
Ah,
somebody
that's
will have
what.
to appoint him. Malas.
Somebody goes with the complaint.
Or-
There is no investigating officer to form an opinion and seek approval. Who will seek approval?
Malas, complaint, now, let me answer my lords. First of all, your lordship will decide it in a true case. Your lordship will not be asked, as they are doing, to decide a
No,
hypothetical.
I am only.
Now, on the inquiry, no, what I'm
Yes.
doing, lordship will answer. There's a very clear answer to your lordship. The dates in this case give the answer. This man files on 18th July. And the governor,
No, 18 July, he registers a complaint.
then 25th additional.
No, that is not taken note of because I see
So-
the order.
So
For want of approval, he does not proceed further.
Then Malas, second is 25th of July, he files a further information to supplement the initial.
Yes.
Then Malas, 26th, he goes directly to governor in less than 7 days, 6 days. Now, the query my lord is putting in a case where there is no action. Malas, maybe a writ will lie to create an action. You can't say, I go today, give him 3 days and I go to the governor and bypass. 17 days can be bypassed
That
because
will.
that's the way to do it.
That will.
But therefore, the escape route to your lordship's very valid question would be that if I try to defy and don't ever give anything, I have no inquiry officer, I have no policeman, I have nobody appointed. Well, the lordship's writ court will settle it in 2 minutes. But whereas here, these dates are important because you are actually bypassing the system of 17A. 3 dates. 18th, he lodged a complaint with the Lokayukt police. 25th, he filed a supplementary information. 26th, he went to the governor. Where will the poor police officer will not function so fast? Even if they have to function. Yes, if I am deliberately not functioning, if I am a police officer,
No.
if I am the state,
First,
etc.
154.1 was 3 days before the going to the governor or registering the private complaint? No. When was the first complaint registered?
It is 18th.
18 June.
No, July.
18 July. First complaint.
Yes. 1 minute. 18th July is the first complaint by Mr. Abraham. Yes.
All right.
And he never approached the court saying that Mr. Policeman, you are sleeping. Mr. State Government, you are doing nothing. Please give a mandamus. Maharaj, if this is so, what prevents your lordship from having hundreds of people coming in saying, 70 days be damned, I am going straight to the governor? That's a point to be considered, Maharaj. Your lordship will
And
then
when
have...
did you go to the next higher authority? 12/8. Huh? 5/7, sir. 5/8. And before that, you had already sought.
He closed the doors. Actually, Maharaj, if your lordship investigates a very important question more, he then has power to go to the court. Not your lordship, writ court. He can go under 154(3) to the SP.
No, that's what I'm asking. 154,
The report,
154(1) jurisdictional police, no action. 154(3) SP, no action. 200 magistrate.
No, I am going further. Writ court will give it for the asking.
And that also, a mandamus to register the complaint.
But you do nothing. You come on 18th, you go home on the 26th and say, look, I am bypassed. Thereafter, nobody is going to touch it. You go to the highest officer in the state.
All right, yes.
So these harm. Now, Manas, just look at the reverse for a minute. Just look at the reverse. This is all right. You don't have an inquiry officer. You did this. Look at the reverse. Is your lordship not being asked to accept a gigantic principle, subversive of the discipline of law, that Manas, this 17A, what is left in it if everybody is going to the governor first? That's my reverse question.
Everybody, why will they go to the governor? Governor is the competent authority only to a few, not to everybody.
No, for any case, Manas, it is not at nobody's case that 17A is not required.
17 is required.
Required.
Yes.
Now the question is that in every public servant case,
To the competent authority.
no, governor oblique competent authority, obviously, governor.
Yes.
Point is, where does the role of the police officer then remain?
After the registration of the crime.
So that's the Malas, that's the
That's
debate.
where we'll
That's
have
the
to
debate.
answer.
That's
We'll
the
have-
debate.
yes.
That's the debate. Then Malas, 27.1. In this case, directly approached, 27.2. The governor not concurred took a different view and passed a cryptic order. Then Malas come to page 40. This, fellows, I have covered now.
Yes.
Police officer is fully covered
Yes.
in the debate which your
No,
lordship
this
just-
argument is over now. Yes.
And then, fellows, your lordship's judgment is also cited.
Yes.
Now, fellows, para 29, fellows, is really a para about uh, this act. It's a point I'm keeping alive. I'm not, fellows,
Yes.
it's a point I've fully said that. Not by any remote stretch shown to be part of the discharge of my official duties. That's the.
That is,
that's
it.
the-
Now we have come to the crux.
So therefore, Malas, Section 17 grants protection from decisions taken or recommendations made in the discharge of their official duties. All relevant timelines and record. Now, Malas, this is not by itself the crux. It is the crux because in this case, you have shown me nothing as to how I have been involved in the discharge, where this is. That is why it's a crux. That is important to remember.
Yes.
My lord has rightly used the word crux because you have to show that I as a minister, I as a public servant, I as the chairman of a department, I as the file signer, I as the file mover, I as the recommendee, I as the statutory compulsory persona designata, something, nothing. But your discharge of official duties is because you are a public servant. So the discharge is as big as the universe, the entire universe. Now let's kindly see. Come to 29.2. The official capacity of the petitioner at various junctures enabled him to assist in fabricating record. Now, well, is this possible? Just kindly see this. This is being told to your lordships, brothers. In pleadings, is this the way to get sanction? And of course, none of this is dealt with. I would have liked the governor to say, I grant sanction of 1 and 2, but I call this bunkum. I reject it. He can still grant against me. See this, brothers. Various junctures assist in fabricating records. Your lordship will not work on adjectives like this. Next, recommendation or decision is made by a public servant not directly or reasonably connected with the official, he is not entitled to protection. Third, it is not the official duty to facilitate the fabrication of fake record. Well, some comma, full stop, some sign, some collusion, some meeting in a smoke-filled, dark-filled room, doing something, well, your lordship doesn't. And this is very easy to destabilize. Anybody will take a pot shot. The petitioner cannot seek or obtain shelter under the aforesaid statutory provision as the offences alleged are not in the. This is, I'm reading his reply.
Yes, yes, yes.
Consequently, contends the prior approval does not apply at all. Then take your chance. Take your chance. You are the one who went to the governor. You are the one who's got all this thing going. And now you are pleading this also. And you are pleading this on one of those amazing facts of fabrication of records. Not a word, not a single comma, full stop, remotely. Then, page 44. It is pertinent to note that since the allegation against the named accused are not in relation to any action taken or recommendation made or other name, there is no requirement of prior permission or approval. Well, this is amazing. It's extraordinary. Now, there is no answer to say that if this is so, Mr. Singhvi, you can be prosecuted without sanction. It is for him to take his chance, not for me. I'm only coming against what he did. I have started nothing myself. This categorical statement is not a concession. Mark 29.4 is my conclusion. And if this is true, then it's also apart from anything else, it's a wastage of public money and public time. If this is so, in addition, I don't know whether there's an offense of public wastage of public time. There's no offense like that. But this categorical statement is not a concession granted by the respondent, but an admission that the fundamental requirements of 17A with regard to recommendation made or decisions taken is not made out in the present case. Therefore, expatiate the impugn order. In that case, the sanction goes on this ground. 17A explicit, and I'm sorry to repeat, this para 29.2 is verbatim reproduction of his pleadings.
Yes.
No note, nothing, pleadings. So your lordship is obliged to rely upon it. I am obliged to rely upon it. The court is obliged to rely upon it. It's a pain of perjury. It's on pain of perjury. Section 17A explicitly grants protection concerning inquiries that are to be conducted solely by a police officer. The clear implication or necessary corollary is that only a police officer has the authority to seek prior approval to lift the bar. This process, much like registering an FIR under 154, 156 or 173, requires the police officer to exercise independent application of mind. This application of mind leading to a further action is the sole and exclusive jurisdiction of the police officer, and no one else can replace him. Criminal jurisprudence has deliberately limited the involvement of private parties, ensuring minimal interference of complainant in order to protect the accused's right to a fair prosecution. It is only through recent judgments by the court that the complainants have been given a limited role. This is important, Malas. Complainants have no role except to the extent your lordship permits them in ABCD cases. This limited role is designed to uphold the integrity of the criminal. Why do you should not give this, fellas? Because you just can't say that you could kickstart the whole thing in motion. Allowing private individuals, 45, to move the competent authority for prior approval would create an untenable situation where the police officer's authority to apply his mind and determine whether a case merits such approval would be undermined. This is, Balas, the core larger legal question Lordship should, Balas. In this case, these dates I have done, but 29.6 I have done, Balas.
Yes.
18th, 25th, and Balas,
Yes.
18th, 25th, and 26th. These are the 3 dates in 29.6. Then, Balas, the SOP.
When was the approvals, before the private complaint, when was the private complaint registered?
13.8 is the private complaint.
Private
registered.
complaint,
13th of August.
right. 18/7. No, 18/7 is the first
Is the
complaint.
first complaint. 25.7 is the supplementary.
18/7, first complaint,
25.7 supplementary information.
yes.
26.7 approaches the governor directly. Can you note one moment? Same day he issues show cause, 26.7.
Fine, that I
Yeah,
know.
that's
That is argued, yes.
And then Wallace goes
No,
on.
that is
13.8.
because-
13.8 is the
That is
register.
because Lalit Kumari says when a cognizable offense is brought before the court, brought before the police, crime should be registered with, everything should be over in 1 week and crime should be registered. If it's not registered in 1 week, next rung. There, if it is not registered in 1 week, next rung, that is 200 before the magistrate.
Wallace, then what?
That's what, no, that is
My lord
the
is absolutely
purport of Lalit Kumari.
My lord is absolutely right. What happened to Lalit Kumari when Sashikala Jolie was pending for 24 years?
That-
24 months?
That is approval, not
something-
Lalit Kumari.
No, but Wallace, I mean, it's the same.
No,
thing.
that parity we'll see, what has happened later.
No,
Because
that's
that
a
is,
lot.
that is something that has happened now during the pendency of this petition.
Yes. No, that is the judgment has come. I mean, the
No,
order has
the
come.
order has come now. It was pending 21
Pending,
days.
pending. Then Wallace,
I'm surprised that is approval or sanction is not
the
even
lordship said, so
clear.
we checked up. We were also
Yes,
surprised.
it is
17,
approval
18
only.
up.
Yes.
Now, Wallace, last, I'm just ending, Wallace. I want to just cover some facts and then I'll
Yes, yes.
try and end. Lordship, give me a few extra minutes, Wallace. I want to.
No,
finish.
take your time.
Wallace, 218 is page 46. I say it is virtually.
1-8 stage, I think, has not
virtually
yet come.
conceded. No, just read this one para only. It is virtually conceded. The Honorable Governor has, apart from granting prior approval, also proceeded to grant sanction. Your Lordship is right, but that's not what the Governor thinks. The Governor says, I'm granting sanction. It's written there, Your Lordship has seen that. During the course of the submission.
218 is what is 197 under the CRPC.
Correct, 190. During the
So-
course of submissions, the learned senior counsel of R2
Hmm.
made a categorical statement that the impugned order is not a sanction order of 218 and must be read only as an order of prior approval. Your Lordship will record
So
this
you
because
need
that
not,
takes,
you need not labor on that.
provided it is recorded. What happens is ambush points are taken. Either
No, no.
side appeals and we say,
Yes.
no, this is not decided by the judge.
No,
But
no,
why will the judge decide this? You have conceded it.
no, that is in the written submission also.
Yes, also.
Yes.
Therefore, Your Lordship, just take that note. I am not arguing for that reason only.
Yes, yes.
Otherwise, Maharaj, I am demonstrating completely that this is wrong. But anyway, he's saying that it is to be treated, this itself is non-application of mind, Maharaj. To start treating 218s or 197s as 17A is itself non-application of
No, no,
mind. But
it's,
leave that aside.
they operate in a
Leave that
different.
aside. Now, Maharaj,
Because 197 is after investigation.
yes. Now, Maharaj, no, he's saying treat it now as a 17A order, prior approval order. That's all.
Yes, yes.
Now, Maharaj, page 47 is very important. Well, it's 3 or 2 very serious errors of law were made and then the facts. Natural justice was brushed aside on the simple point. Notice was given to me and so what, I didn't send you the other 2 complaints. I was not required to give notice at all. That's the very, very far-reaching. So first argument, I gave you notice, but I was not required to give you notice. But since I'm not required to give you notice, I'm not required to send you the other 2 complaints. So my own definition of natural justice applies. And third, so what does it matter, Mr. Singhvi? There is no prejudice to you. Let's get on with the matter. All these 3 things are answered by the Supreme Court evocatively, and my learned friends have completely misrepresented the law on this point. The law is totally different. Just come on prejudice for us first. Dharampal, page 48. From the above discussion, it becomes clear the opportunity to provide hearing before making any decision was considered to be a basic requirement in the court proceeding. Later on, this is all very common, so we ignore it. The more common, the more important is to underline it. The Later on, this principle applied to other quasi-judicial authorities, even in administrative, before taking a decision, hearing is necessary. Boldface, Krepak, etc. Now just see what he says, Wallace. So far, so good. However, an important question posed by Sorabji is as to whether it is open to the authority, which is to take a decision, to dispense with the requirement of principle of natural justice on the ground that affording an opportunity will not make any difference.
No, that's not.
To put it differently, can the administrative authority
No, it
dispense?
can't be said. Or even if I give you notice, what will you say? That cannot be the reason
That's
at all.
I was not
That
required to
can't
give
be.
you. Even if I gave you, I'd have the same result. No prejudice would happen. These are the angles of the same argument.
But here, he only extracts one paragraph in the order saying that there are two other complaints. No contents of that complaint is noticed.
That's my grievance. That's my grievance. Because he has already sent me notice. So now I'm dealing with 3 points. Well, one, if you elect to send me notice, you are stopped from arguing that no notice is required. That's proposition one. In administrative law,
Yes.
if you elect, I did not elect, you elected. You elected to send me, then you cannot say that now notice is not necessary. Second, if you elect to send me and do not send anything else, then you cannot take the plea that even if I had heard you, nothing else would have happened. They are the two main propositions.
All right.
Now we'll just come to 31.3.1 at page 49 bottom.
Yes.
49 bottom. The request for prior approval or receipt by the governor on the same, and third, I'm very sorry, third is the most important. He gave a detailed half-day hearing to the complainant. It can't be brushed aside by saying criminal law. I can hear whom I like. He heard the criminal law complainant. He gave me notice. Then he did not give me the notice for the other two and then said no prejudice. That's the fourth. Let's put them all together and whatever the conclusion is. The request for prior approval received by the governor on the same day a detailed hearing is granted to the person seeking. Same day. The governor further finds a prima facie view on this meeting alone and proceeds to issue show cause. Such view was formed despite the fact that documentation was mostly in Kannada. The detailed set of the governor is obviously not Kannada. So very detailed. 200 pages. I have seen, my learned friend has seen all Kannada. Obviously, he didn't learn Kannada overnight.
This is prima facie case Allegation.
Prima facie case. No, these are important. If you are doing this application of mind,
Yes.
what if the mind can't apply in a language you don't understand? What application of mind in a language you don't understand? With this? The detailed set of documents provided by the third is in Kannada, application by fourth is in Kannada, fifth respondent is not even on file. The Honorable Governor, as can be seen from the response to the RTI, admits that he needed an English translation. He writes the file to proceed with the other application for prior approval.
Aid and advice of other officers.
Yes, for the others. But in the present case, Kannada seems to be the chosen language. This is in the other cases. Here, on the same day, on 26th July, he proceeds.
Yes.
In the present case, English translations were done by the governor's office is not borne out from the records. Whereas in the other cases, investigating agencies are directed to file translations. There's an order noting. Now, this is the direct proof. Well, this matter, this particular order must be set aside. Whatever order he has to pass, etc., is a different matter. The Honorable Governor, on the basis of a petition accompanied by more than 100 pages in Kannada, come to the conclusion the allegation serious nature and prima facie need action. Also notices that complaint is filed to the Lokayukt police. It is rather surprising and ironical that the Honorable Governor, unable to read and decipher Kannada, is also able to digest documents of hundreds of pages, etc., and issues notice immediately. There is undue and inexplicable haste. This is not a facetious thing. It all adds up in the overall. It's not just a light game that I'm saying he doesn't know Kannada. That's not the point. He's not expected to know Kannada. I'm not suggesting a lordship. In fact, in the old days, there used to be a bar that you're not, even today is a bar. You can't be from the same state if you're a governor. The application for prior approval.
It's all right. How can you interfere? Yes, I am aware of that.
The application for prior approval sanction is received by the Honorable Governor. Addendum is on 26th. Addendum is also received same day. Let us kindly see page 51. Opportunity of detailed hearing of 3 hours is provided. And by 10:30 on the same day in the night, 10:30 p.m., a show causes notice issued. A process in such a manner by one of the highest constitutional authority against another highest constitutional functionary is unheard of. I'm saying this with a sense of responsibility. Such application, the Raj Bhavan would on the same day reach the governor, and then hearing to a private party takes place on the same day, a show cause. This is all Article 14, etc., etc. And your lordship will see the totality of the earlier arguments also. Then, Malats, 31.3.4.1 is page 52. Sashikala Jole, all the dates are given to your lordships in one place at page 52. Murugesh Nirani is the other case,
That is also pending?
returned on
Returned.
28/8. All is happening after this case has started. He's either returning or rejecting. Approval is only my case. Now you have to explain the delay. Well, it happens even in the judiciary. Sometimes after 2 years, the matter is put again for clarification. So here, after 2 years, in Nirani's case, he sends it for clarification on 28th of August. Then, same thing about H.D. Kumaraswamy, returned to the requesting authority. Then, it is very clear the dates are all after the hearing of this matter has started or after this matter has become a dispute. Not hearing started, but dispute. Then, application of 13th of May submitted for sanction was returned by the governor in June 2024. On 21/8, investigation replied. On 28/8, the application was returned for English translation. Well, by the way, each of these, that is, page 52, all the cases except Shashikala, page 53, all the cases are returned after they come back from the clarification, further returned for translation. I hope I'm clear. Take, for example, 53. My case, the same day, the night, same thing. Now, let us see this ground. This is very, very important, 53. In Shashikala, he does exactly what I've been laboring the whole day today. He did not do in my case. That is
Rejection.
quoted. It is quoted once. He has given, I'm not saying it's right. I'm not saying who will challenge, not challenge, what your lordship will decide. But is it anything your lordship found? Just glance at it. Any word similar in my case? Please. In the chief secretary in his report says on 23rd of March, no proposal for grant of any tender. In such circumstance, the question of asking for a bribe does not arise. This is what I wanted, Maras. This is the meaning. Your lordship is asking me what the review judicial. This is judicial review. We don't need.
Wait, sir. I'll get back to you. Wait. Yes.
In order to attract the provision of 730, there must be a receipt for the bribe amount. The mere statement one was paid 25 lakhs paid, whether he received the amount is not clearly disclosed. For sanction on inquiry necessary to prove the demand of illegal gratification. So Malas, he's doing the ingredients of POCA. He's writing. And then Malas, he says, hence I find now.
20.
Then Malas, para 20 is red, it's already red. Then Malas, 55. I will skip till 59 because I want to take a lordship's 10 minutes on that dates. 55 to 59 are largely dates, fellas. So lordship may just give me and then I'll come back to it because the matter ends at 62, but just come to 63. Just come to 63.
List
Now,
of dates.
Yeah, they just note on the side.
Yes.
All these documents are in the writ or filed by them. Number two, I have not gone into it. My learned friends have gone into it meticulously in the arguments. Half the argument, 3/4 of the argument, Mr. Maninder Singh was on these facts. 3/4. And others. But I want to now show the true facts. And what I've done in the table is document 1, document 2 I put on the left side. What she's got? 63.
Yes, yes.
I made one compilation of all. They're already there in the writ or elsewhere. There are 4 new documents. One is Shashikala Jole, which is not a new document, subsequent development. One is the plan, which is all are mentioned. Apart from Jole, each and every one is mentioned both in my petition and in the cabinet sanction or denial of sanction.
All right.
All mentioned. Now just see the startling consequences very quickly. Malas, 92, your lordship has a notification. Then Malas, the old fellow, the earlier owner is Malas Devaraju in item 4. When I say 4, I mean document 4.
So, Devaraj is the owner?
Then owner.
Was not there a relinquishment in favor of one Cheluraya or something? Mailaraya. How did Devaraj become the owner?
No. That is much.
1945.
Subsequent to that, a release deed in favor of Devaraju.
Where is the release deed in
Yes,
favor of
yes.
Devaraj?
Give me the page. Is it on record? It is mentioned. Where is the and the averment in the writ? and the amendment in the writ.
Now, since you are replying on facts.
No, no, it's very
Should
important.
be clear.
Very important, very important.
It's 10th of April, 1993.
Yes, Rangnath,
10/4/93.
ನೀವು ಹಾಕಿರೋದ್ರಲ್ಲಿ, there is one relinquishment deed
Ah.
in favor of one Mailare or something, yes.
Now, 10/4.
1935. It was 1935.
No, no, let us see. The date of the, there one thing, say, one thing.
Hilary was 1935 from the same family.
What the date?
10/4/93.
10/4/93 is well as in the documents file, give the file to my lord. Page
It's-
11,
We gave it in the morning.
page 11.
Oh,
11 to
it is release the land in favor of Devraju, is it?
Yes.
Yes. This is, we are talking of 93.
Huh. Which is that I have not seen this document at all.
It is,
Yes,
Right.
Rangnath, you have not produced this? No, which is this 10/4/93 document?
No, no, this is produced now, Malas. It's produced.
Now it's not a part of the record. No, nim record allu ಹಾಕಿಲ್ವಾ ಅದು?
It is recorded in the writ, it is recorded in the cabinet thing, but document is this. Cabinet,
Where is that document?
this one, page
it
11,
is given in the morning.
that bunch we given Malas.
In the morning. we
All
gave
of it is in the writ or the cabinet decision, this bunch, kindly give the bunch. No,
All right.
no, morning, just show the bunch.
ಬೆಳಿಗ್ಗೆ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಹಾ.
This document mentions in the writ.
It is not in the.
It is mentioned in both Malas, my reply to the governor and in the cabinet decision.
Yes.
Now Malas, kindly come to, I obviously can't read it.
No, no, that
And
document number 3,
4, I think.
4 is it?
4. 4?
No, in
Three,
this
three,
you
three.
say document number 3, 10/4/1993.
Document 3.
ಭೌತಿಕಾತ.
Well, just for fun, we have made serial number 4. Foolish, why did you make
It's all right. ಭೌತಿಕಾತ ಒಬ್ರಿಗೆ ಹೆಂಗ್ ಹೋಗುತ್ತೆ?
Ninga is no more.
ಲಿಂಗ is no more ನಿಜ. 3 ಮಕ್ಕಳು. ಭೌತಿಕಾತ ಆದ್ರೆ ಅದು ಒಬ್ರಿಗೆ ಹೆಂಗ್ ಹೋಗುತ್ತೆ?
memo?
Surviving 3 brothers.
Let's see. Yes.
Right,
All right,
Malas?
yes.
Now, kindly go ahead. Then Malas, this Devaraju makes an application in document number 4 for Malas deletion.
Yes.
Then Malas, a resolution is passed in, well, look at this person who is trying to grab all this and is so corrupt. We're talking of 93, 97. That itself, Malas, and a person comes today, I'll read that para about the antecedents of those who have come now. Keep that para ready, keep it out. Document 5 passes a resolution that they can be excluded in 97. Then Malas, notification is issued. Now the Commissioner Muda recommends for release.
Yes.
General award is passed in document 8.
Yes.
Denotification is again recommended to 9. It was made to sound like a huge conspiracy that there is no denotification at all. These are all Malas.
No, denotification is there.
Assume it is wrong. This is a government process going on. It is not something which I am the minister in charge or is done for me or not for others. Then Malas 10. Denotification is issued under 48. The Rosh was specifically told, where is 48? This is no 48. This is all false 48. I was there, Malas. It was 48 was just brushed aside as some kind of thing. What is this document, Malas? Item 10, page 47 to 51 in the writ. Then Malas, approved layout plan is important. This is mentioned again in my and Malas the cabinet, but I produced it at page 52. How do you approve a plan, Malas, by saying denotified? Can a lordship have an approved plan without of denotification without it actually happening? Somebody will go for forgery, Malas. And forgery would have happened, Malas, in 98. We are in 2024. Then Malas, very irresponsible and extremely rhetorical and hot-blooded accusations were made, making the whole thing look like a scam for 23 years. Ignoring all this, and people who knew so much to say also had all these documents. Those who argue with all this vehemence are deemed to have all these documents. You can't argue, so I did not know. If you did not know, you jolly well be responsible and don't raise it in so irresponsible a manner at such a high pitch. Then verse 12. Notification does not show the lands in question. Now this is because it's denotified. This is the reverse thing. I'm showing an omission in item 12. An omission. Now you can say that all the documents for 25 years have been forged. Thankfully, you have not said so yet.
No, that's not.
You're
there.
not thankfully till now said so. Then Malas personal award is passed in 13. Now it is possible, Malas, that despite this, I'm such a superhuman human being. But this is not a ground automatically without adverting to a single fact to grant a sanction. This is not the kind of case a Lordship Malas has cases where Lordship has. What has happened in Malas, the precedents have muddied the field because you have corrupt people. You have people with the same day, same this thing and all. Fast. This is not that kind of case. This is proceeding at, if at all, a inordinately slow pace in my view. In my view, a very slow pace. 13, personal award. 14, illegal allotment of sites on paper. This is a reality. Please check up. And Maharaj, at 61 to 71, it is found Mr. Abraham's application. Mr. Abraham's application. And they have argued, and he has argued such vehemence.
No, allotment of sites is not on paper. It has actually happened. To
It is on
the
paper also.
allottees of the layout, it has actually happened. Yes, Raghunath. It has actually happened.
Paper.
Yes.
Maharaj, may I say,
Correct. Yes.
de facto 100%. 100% de facto. Muda is dealing with it. Nothing on the paper will happen. Nothing on the ground will happen without the paper, Malas.
True.
It can't be that in the air. This is a Muda authority. Document 14 is found, Malas, 61 to 71. Lordship may see. I put the page. What else can I do, Malas?
All right.
But
Yes.
this is not a figment of imagination. And none of this is dealt with by the governor. First time a sale deed happens is 2004. So Lordship will draw a line
Yes,
here.
first sale
from
date is
97
2004.
I mean, sale deed relevant to not him, but his brother-in-law.
It is
I mean, not him, but his brother-in-law. I'm drawing a line still. This is Malas from 92, 93, and Lordship is stopping at 2004. This is a whole decade. Then Malas, conversion of lands is applied. This is applied in 2005. And Malas, just see the next date between 16 and 17.
5 years.
Such a mad rush because he's been in politics all along, Malas. He's been either an MLA or he's been a deputy chief minister or a minister. He became a minister in the 80s. Such a mad rush, man. He must be madman, Malas, that he's taken 5 years to have a gift deed to his wife. That Lordship reads the totality, the holistic. This is not some kind of a scam, Malas, where the man is desperately trying to grab something. He's taking 5 years from 16 to 17. Then Malas, 18. This lady Malas requests to allot alternate land. Now, it is not the only lady who gets it. It is not the only case of encroachment. It is not the only time it has happened. It just happened that I am the chief minister's wife also. Then Malas, 19. Proceedings of the meeting where the application is discussed and decided as follows. This is Malas 90 to 94. This is, Lordship, just note that. That thing your Lordship asked me. Just note on the side.
Yes.
My son is officially ex officio, Malas, all MLAs. I've checked.
Yes, all of them.
So
Not
that is one.
only,
No,
I'm
no,
not saying that
no,
it's
no.
only
I-
yours.
My Lord asked a neutral question. I'm giving the facts only. I'm also giving a neutral
As
answer.
an ex officio member of Muda, being
All
an
MLAs.
MLA of the constituency, you had participated in those deliberations which decided to allot alternate sites. As
Number
the
two, no, but there's
topic.
something more interesting. Malas. The minutes of the resolution of that meeting are fascinating. They are in the relevant, the same volume, page 96. All the people, including MLAs who participated,
Yes.
contributed.
Yes.
This man did not say a word.
That's all right.
No, no,
Yes.
I'm just saying there's no participation.
Yes,
He's sitting,
yes.
he's attending. There's no participation in decision making. None. None.
I'm not-
And this complaint is against me.
No, the complaint is against you.
Yes.
That's all right.
And fourthly, that person, my son, is not made a accused. Now, Malas, if it is private,
Yes, all right.
right. Now, Malas, very well. Now, Malas, today, if Malas, I am to be culpable because of this one incident of 19, which is happening in 17, when Malas, this event happens, then Malas, your Lordship will see the totality also. That's the point.
No, their allegation is the beneficiary is the roof.
I understand. Malas. This is the allegation is much
The
more.
roof of the chief
This
minister.
son came now, Malas. The allegation is that this is happening from last, all the decisions, this denotification is the allegation. The encroachment is the allegation. No son, no father, nothing but it's the allegation. This is only the Malas consequential decision which is coming up now. That act has happened.
It's an
earlier.
allegation, not a conclusion. It's an allegation.
Now, Malas, my first point is, Have you dealt with it anywhere in your order, Mr. Governor?
That will, yes.
Have you then shown that is there any connection with me in a manner which can be credible? Have you addressed it? There is a whole para which addresses it in the cabinet decision.
Yes.
Have you then dealt with that para and said this is wrong because of 1, 2, 3, 4?
That I will answer.
This is the. And then, Wallace, then of course, willingness given.
What?
Now come to Wallace, document number 23. No,
Can I just-
sorry, before that.
No,
no.
it's- no, it's
20 onwards, Wallace.
speech again, but I don't
20,
think that is
20
there.
onwards is very important. Just draw second line at 20. That is 14, 11, 19. I am in the opposition. But should I put that line there? Item 20.
No, yes.
Now then, Wallace, the principal government department writes to Muda to take a decision at their level. Proceedings of the meeting of Muda where it decided to give 50% of developed area as compensation. Willingness given by not me, but by Wallace, 14 or 15 other people across the state, or where not across the state, in the relevant areas. Then Wallace, relinquishment deed, etc., the last 4 days. Now, Wallace, the last part
Say 50-50.
is
Look
come
at
to
people
Wallace,
who
the
can benefit.
submissions at page 55. Come to 55, the submission, I am done, Wallace. So, Wallace, there has to be a proportionality for this one meeting and most of the time outside of the power. If you are going to go that far, then Wallace, totality doesn't justify, you have not dealt with the administrative law aspects.
You told me to remind about these antecedents.
Then, Wallace, come to para 32 of my note, page 55.
55.
Yes. So 32 and 33 gives the same list of dates. All the way, Wallace, to the end of 56. Come to 57 top, the denotification is not specific to the subject lands, extended to other lands.
No, it is, denotification is not only this land, it is something else. A denotification happens to the adjacent land. That is also there on record.
19 is what I've said, Wallace, at page 57, 19
What is
examples.
this survey number denotified?
464.
462. 46.
462 now.
462.
One person.
464.
462 or 464?
462 and 464.
460.
19 is the problem.
Now 19 other is important, Wallace, at page 57.
No, all that is there.
Yes. Then, Wallace, just note that these are impressions given to your lordship in the prejudice part of the argument. Therefore, I'm just very quickly clearing them. Now, Wallace, 33.3.1. The notification does not, under 16.2, does not cover the lands in question. And the lands were therefore excluded. This notification is 33.3.1, Wallace, of my note. No Panchnama, no inquest report, no memorandum, no sufficient documentation as required under Indore Development Authority regarding taking over of possession. Your lordship is told taking over of possession. Then, Wallace, now, this para 33.5 I have put in boldface. And you just see it for a minute. Allegations questioning title are based on suppression of the crucial family settlement. Now, Wallace, you are questioning my title. Inside my family, there is no dispute. It's a family settlement at para 33.5, number is given, register is given. There is no jhagda, but Wallace, somebody else is
No,
questioning.
that's not the submission also.
Then, Wallace, that other writ, Wallace, is identical for this reason. That's very important, Wallace, to remove that impression. Where, Wallace, the matter was not proceeded with and the land was released.
Which one, sir?
Other writ was said that we have suppressed the writ number and all that.
Sundarama.
Sundarama's case. Sundarama's case is only cited for the point that another case where actually acquisition was not
Oh,
continued.
that Justice Bhajantri's order.
Yes,
Yes.
it is not continued. So also in my case, acquisition is
Yes,
not
one
continued.
second.
Just 5 minutes more.
Yes, one.
So 61 is very important. 50-50 benefit given by, taken by hundreds of people. It is not just me who's got it. 61, we have made a chart.
Yes, sir.
Now, Wallace, that other matter, just see 61 and I'm done in 2 minutes, Wallace. 61 is a list, this is important. I put a chart.
Yes. and
This
there-
Muda Look at what it did for an overall policy, Malas. Look at the number of sites, Malas. 50-50 ratio. This can't be, Malas, any kind of an individual case, Malas. Then sanctioned without land acquisition, 570. First one is without compensation, 358. Without acquisition, 570.
Yes.
Then prior to the date, 99. After the date of 5/1/22, 835. This is completely, well, it's to particularize it as if some kind of conspiracy by an interested party is wrong. This is all Karnataka thing. Then, well, Sundarama is important because, just note one thing, 33.8.3, which is at page 61.
There is no distinction between the case.
That was what was thought to be said. There is a vital distinction. There is none. Where land acquisition is not initiated, and a case where land acquisition is initiated, but the land is later denotified. That was the example being given. We have given an analogy. We are not saying we are that case. We were saying that land acquisition was in the process of not initiated then. Mine was the case initiated but withdrawn. So the result is the same. There is no distinction. Lastly, just note my writ para, page 31. Page 31. This also
Of the writ petition? No, of this.
31, yes, in
Sub-
the main writ petition.
Yes, it mean it.
Main writ petition. 1, 2, 3, 5, 6.
Krishna, you said nip it in the bud.
Yes. Page?
Well, it is also important for such matters. It is not that it is a rule of law, but the sanctioning authority gets a feel of the case. It is not that everybody on Malas will come and start doing this. Frivolous, vexatious, or dubious antecedent people should never be encouraged because this is a much larger repercussion. You are protecting public servant anyway. Here you are protecting a public servant against dubious people of dubious antecedents with frivolous, vexatious objectives.
What's dubious?
Yeah, come, 31. 31.
No, who's dubious here?
This particular person was 631.
Page 31.
When you're reading the paragraphs, the credit, no.
Oh, antecedents of respondent number 3.
This is one example. Let me, Mr. Abraham is a crucial factor. He is a habitual litigant, well-documented history of engaging in blackmail, extortion, and the misuse of legal processes.
No, I would put it this way. Yes, it may be. A whistleblower will always face these problems.
Provided he doesn't have, a whistleblower need not have an antecedent thing. This is not
No,
this
any
25,
any whistleblower will always face this problem.
Correct. Will the Supreme Court impose 25 lakhs cost on a whistle? There can be whistleblowers
him-
without this.
on
Next
him?
sentence, please
All
read,
right,
Bharat.
yes.
It's not
see.
a-
Yes.
He is a habitual, I have put words here, Bharat, advisedly. He is habitual litigant with a well-documented history of engaging in blackmail, extortion, and misuse. His conduct has been repeatedly condemned by various courts. Supreme Court imposed a cost of 25 lakhs in SLP. 25 lakhs is not given in 2017 in even 1 or 2 cases for abusing PIL. In addition to the history of vexatious, respondent has been involved in criminal activity. But your lordship is a judge who takes a holistic view. Ultimately, judges have to take holistic view. FIR registered in 2023 for offences including, can't you have whistleblower without all this, fellas? Extortion, outraging the modesty of a woman, criminal
Outrage of modesty.
intimidation under sections 384, 506. Complaint filed by Sudha, a government official, alleges that Abraham attempted to blackmail and
384 is
intimidate.
not outraging modesty of woman.
What is the
Oh,
which is the
that
section?
matter. 384 is extortion.
384 is extortion.
All right, yes.
The complaint filed by Sudha, a government official, attempted to blackmail these serious
Sir,
criminal antecedents evident
If,
that he
sir,
lacks.
if we can do this, you give me 5 minutes, I'll resume. Whatever it is, I'm going to complete this today.
I have in fact finished. Melissa.
Yes, sir. I'll get back in 5 minutes.
Certainly,
Yes.
certainly. Sorry? He's going to you want to argue, you can argue with me.
Yeah. You have practically covered,
No, but
I just
whatever you want to
take him
say,
through.
yeah.
I'll take him through those.
What I'm saying is. Anything else? Anything else? No. Coalition through opposition government came on 26 July 19. Just note the 3 dates. Whereas there was in between small coalition period. Then was the government of the current central government ruling party came on 26 July 2019.
Huh.
Well, it's the official principal secretary level decision to say that Muda will take a decision at their level, entirely delegating to Muda, is published on 14/11/19. That is 5 months after the BJP government had come.
All right.
14/11/19. And finally, the Muda, acting under that government mandate of a different government, on 20th November 2020, decided to give 50% of the developed area as compensation. Wherever Muda has not acquired land or not proceeded to acquire fully.
Not acquired, but utilized.
So therefore, Manas, these are the 3 crucial dates. Of course, one of my learned friends here on the other side have gone to the extent of saying, and I have no illusions about myself, but she certainly has illusions about me, that I was so powerful even as the opposition that I engineered this. I am very happy for the compliment, Wallace, but I'd rather live without such left-handed compliment because I have no illusion about my own power. But Wallace, anyway, these 3 dates are crucial because the operative thing is happening 5 months after the new government and 7 months Wallace, at the end of 2020. 1 year after that first. So decisions are 14/11 and 2011-2020 next year.
Yes.
So Wallace, this is when all this has happened. And without that consummation, there would be no such complaint. That entire consummation, the actual so-called, if I may say, Wallace, the fruits of crime, I mean, I'm not saying crime, but have happened entirely during a BJP government.
While you were in the opposition.
Very, very deeply obliged for a very patient hearing.
Yes, yes.
Good, my lords, excuse my absence. My friend may
Yes,
add
yes,
something.
no problem. Yes.
Very deeply obliged.
Yes.
After the argument started, a sheaf of papers are given before the court, saying that they are the proceedings of the government,
What papers?
records of the governor.
ಈಗ.
ಅಲ್ಲಿ ಕೊಟ್ರಲ್ಲ ಆಗ್ಲೇ. That
The other day.
Ah.
Yes, yes. All right. All right.
may request the court to kindly take those
Yes.
papers for a minute.
ಗವರ್ನರ್ ಕೊಡಿ. ಅವ್ರ ಇದ್ರಲ್ಲಿದೆ. R2 ಏನೇನಿದೆ ಎಲ್ಲ ಕೊಡಿ. ಬಂದ್ಬಿಟ್ಟು ಮಾಡಿದ್ದಾರೆ. ಇದಲ್ಲ. ಸರ್ ಯಾವ್ದು ರೆಫರ್ ಮಾಡ್ತಾರೆ ಮೆಮೋನಾ?
No, no, governor's file.
ಗವರ್ನರ್ಸ್ ಫೈಲ್ ಅಲ್ಲ ಇಲ್ಲಿ ಇದೆಯಲ್ಲ ನೀವು ಓದಿ. ಇದ್ರಲ್ಲಿದೆ. ಎಸ್ ಸರ್.
Yeah.
ಇಲ್ಲೇ ಇದೆ. ಎಸ್.
Sir, kindly come to page 3,
ಎಸ್.
paragraph 8.
ಎಸ್. ಎಸ್ ಸರ್.
This is the first order passed by His Excellency, the Governor. I have heard Sri T.J. Abraham
ಎಸ್.
in person,
Hmm.
gone through the petition and supporting documents submitted by him. Prima facie, I am of the view, there might be irregularities and misuse of power. Kindly mark the words.
Yes, there may be.
There may be irregularities and misuse of power. Hence, issue show cause notice to Sri Siddaramaiah. I'll refer to the show cause notice, what it is. So
Yes.
this is the first signature in the file
Yes.
on 26/7.
Yes.
Now kindly come to the next signature. Page 5.
Hmm.
Same day.
Hmm.
This is to send the notice.
Yes.
Draft copy was approved. It is being sent. Then as per the orders of the Honorable Governor, draft copy of the letter again same it repeated.
Hmm.
Page 7.
Hmm.
So this is the first sign of application of mine, put up along with comparative statements of petitions.
Yes, because there were other complaints.
Comparative statements of petitions, Chief Minister's reply, and Cabinet decision.
Yes.
So this is the first direction.
Yes.
Now thereafterwards, His Excellency passes another order on 14/8.
Yes.
Peruse the file,
Yes.
discuss the issues,
Hmm.
hence resubmit the file along with notes, analysis, points as dictated, based on the comparative statement and available documents and petition. So this is on 14/8. Now thereafterwards, the final order comes. So these are the only deliberations of His Excellency. Now what I want to show is, kindly come to para 25. Now this is a file built up on the representation of or the application of Mr. T.J. Abraham,
Yes, Abraham.
which was filed on 26/7.
Yes.
Kindly come to page 9.
All right.
There is a reference to 3 petitions.
Yes.
Item number 3 is a petition from Snehamayi Krishna,
That's the fourth respondent.
dated 5/7.
Hmm.
I want to know where is that file? Why it is not placed before the court?
So it is in the original file.
No, it
Not
has,
there in the original file. All right. Yes.
anyway, it is not given to us.
No, original file is not given. Only the.
ಅಲ್ಲ ಕಾಪಿನೂ ಕೊಟ್ಟಿಲ್ಲ. No, what I want to tell the court is, ಅಷ್ಟು ಪ್ರೀತಿಯಿಂದ ಅಬ್ರಹಾಂ ಕರೆದು ಕುಂಡ್ರಿಸ್ಕೊಂಡು 90 ನಿಮಿಷ ಮಾತಾಡಿದ್ದಾರೆ. ಸ್ನೇಹಮಯಿ ಕೃಷ್ಣನ್ ಪಾಡೇನಪ್ಪ ಅಂತ ಅವ್ರನ್ನೇನಾದ್ರು ಕರೆದಿದ್ರ, ಅವ್ರನ್ನ ಮಾತಾಡಿದ್ರ, ಐ ಥಿಂಕ್ ಮೈ ಲರ್ನೆಡ್ she will not interfere with my submission.
All right. Wait.
5/7/2024. That is the first application given. What is the deliberation of His Excellency on that petition? Is a file opened at all? If so, what are the orders passed? Why notice was not issued in that first petition that was filed before? So is the case with Pradeep Kumar,
The fifth respondent.
fifth respondent. So this is one issue which needs to be addressed. Now, be that as it may, kindly come to the order that was dictated
By the governor.
by the governor.
Yes.
That is what
Yes.
the
that is
note
what-
says.
Yes.
Governor doesn't say this is the order. No, notes. We have to infer that this must be the order.
Dictated.
Dictated. Now, para 27 onwards
Is the dictation.
is the supposed dictation. Kindly come to. So the first one are all in the nature of preamble. What happened? Para 30 deals with Council of Ministers and the contents of the cabinet
Yes.
advice. I'll not trouble the court with the text of it because it only extracts what the cabinet has advised. Kindly come to para 31.
Hmm.
In view of the averments made in the aforementioned petitions, seeking grant of sanction for prosecution and the materials in support of the same, the subsequent issuance of show cause notice dated 26/7/2024,
Mm.
reply to the show cause notice by Sri Siddaramaiah, Honorable Chief Minister, legal opinion of the learned Advocate General, and the decision of the Council of Ministers dated 1/8, I am of the opinion that in exercise of my powers under Article 163(1) of the Constitution of India, considering the aforesaid materials placed before me and the facts and circumstances present of the present matter, as a matter of propriety, I shall exercise my discretion. So this is where His Excellency comes to the conclusion that he will exercise his own independent.
That is because he concludes that the decision of the cabinet, decision of the Council of Ministers is irrational.
No. Previous paragraph, there is no such thing. Court,
Allah, the order.
Allah, I bow down to Allah. We can't disjoint the order from the note.
Alright.
Order is a product of this. I will also demonstrate how it is a product of this very note.
Yes.
Because the order by itself does not contain any.
No, order does not contain, but the order does contain the words. I decided to exercise discretion on the score that the Council of Ministers' decision is irrational.
If I may say so, the order is a very interesting order.
No, page 44 of the petition, the order says.
ಅಲ್ಲ ಅದನ್ನ I'll deal with it. ನನ್ಗೊಂದು ಕತೆ ಜ್ಞಾಪಕ ಬರುತ್ತೆ. ಒಬ್ಬ ಭಕ್ತ ಅವನು ವೈಕುಂಠಕ್ಕೆ ಹೋಗ್ಬೇಕೋ ಕೈಲಾಸಕ್ಕೆ ಹೋಗ್ಬೇಕು ಅಂತ ಡಿಸೈಡ್ ಮಾಡ. ಈ ಡಿಸೈಡ್ಸ್ ಟು ಗೋ ಟು ಕೈಲಾಸ, ಶಿವನ ಹತ್ರ ಹೋಗ್ಬೇಕು ಅಂತ. ಆ ಹರಿಗೆ ನಾನು ಪೂಜೆ ಮಾಡಿದ್ರೆ ನಾನು ವೈಕುಂಠಕ್ಕೆ ಹೋಗ್ಬಿಡ್ತೇನೆ ಅಂತ 2 ಲೋಲಾಕ್ ಕಟ್ಕೋತಾನೆ. ಕಟ್ಕೊಂಡಾಗ ಏನಾಗುತ್ತೆ, ಹರಿಗೆ ನಾನು ಯಾವ ಕಾರಣಕ್ಕೂ ಪೂಜೆ ಮಾಡಬಾರ್ದು, ಕೈಲಾಸಕ್ಕೆ ಹೋಗ್ಬೇಕು ಅಂತ. ಬಟ್ ಅವ್ನು ಎಡಗಡೆಗೆ ತಿರ್ಗಿದ್ರು ಹರಿಗೆ ಜ್ಞಾಪಕ ಬರ್ತಾನೆ, ಬಲ್ಗಡೆಗೆ ತಿರ್ಗಿದ್ರು ಹರಿಗೆ ಜ್ಞಾಪಕ ಬರ್ತಾನೆ. ಸತ್ತಾಗ ನೇರ ವೈಕುಂಠಕ್ಕೆ ಹೋಗ್ತಾನೆ. ನನ್ನನ್ನು ಯಾಕಪ್ಪ ಕರೆಸ್ಕೊಂಡೆ, ನಾನು ನಿನ್ ಭಕ್ತ ಅಲ್ಲ, ಶಿವ ಭಕ್ತ ಅಂತಾನೆ. ನೀನ್ ಮಾಡಿದ್ದಿದೆ ತಪ್ಪು. ನೀನ್ ಪ್ರತಿ ಸಲ ಲೋಲಾಕ್ ತಾಕ್ತಾಗ್ಲು ನನ್ ಜ್ಞಾಪಿಸ್ಕೋತಿದ್ದೆ, ಶಿವನ್ ಜ್ಞಾಪಿಸ್ಕೊಳ್ಳಿಲ್ಲ. ದಟ್ ಇಸ್ ವಾಟ್ ದಿ ಗವರ್ನರ್ ಹ್ಯಾಸ್ ಡನ್. He is obsessed with the cabinet note. All right, he rejects the cabinet advice. After that, what has he done?
So that was the material before him in reply. So he has to look into it.
That he has not done.
That
For
here in
example,
the order. yes.
Chief Minister's reply is there. I will point out that also. Not a whisper in the entire order. Not a whisper in the order sheet.
No, the defense was that Chief Minister's reply, the cabinet note are verbatim similar. So one is taken into consideration.
We can reject.
Wait, Rangnath. Yes. Adalle irli. Yes.
No, cabinet.
No, that is the
No,
argument.
cabinet advice may be refused to be looked into. That he has said so. But he can't refuse to look into my reply.
No, the argument was there verbatim similar.
That order should say so. Your argument to. Our argument ಹೇಳಿದ್ದಕ್ಕೆ
Yes.
may I request the court to kindly just one paragraph I'll show. Mohinder Singh.
All that para 8, 851, 78, 851, para 8. Yes.
May I just read that? And the second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or otherwise.
Of objections or otherwise.
Otherwise, an order bad in the beginning may,
Will get validated.
by the time it comes to the court, on account of a challenge, get validated by additional grounds.
The orders are not like old wine getting better by the day. Yes.
Govardhan Das Banji, quote, public orders publicly made in exercise of a statutory authority cannot be construed in the light of explanations subsequently given by the officer, not even by the contesting. Even if the officer gives it, it can't be accepted. Making the order of what he meant, or of what was in his mind, or what he intended to do. Public orders publicly made by public authorities are meant to have public effect and are intended to affect the actings and conduct of those to whom they are addressed and must be construed objectively with reference to the language used in the order itself. Unquote. Orders are not like old wine becoming better as they grow older. So that is what, so it has to be summarily rejected, whatever arguments or justifications are given. I'll come to the order later. Now kindly see that the court says there is a reference to it. May I take the court to the impugned order, volume 1 of the petition. Alla, ee ಕೊಟ್ಟಿದ್ರು.
Same. ಇದೆ. Volume 1 of the petition.
Volume 1 allive.
Yes, sir.
Paragraph, page 41.
Yes.
Para 1 quotes the order.
Yes.
Para 2 quotes the two petitions given.
Para 3 show cause notice.
Para 3 show cause notice. Para 4
Committee.
council about the committee.
Yes.
Then para 5 the resolution of the
decision.
cabinet
Yes.
resolution. I have considered the decision of the cabinet dated 1/8. That is para 6. And file in relation to the issue at hand. It is noticed from the said file that Sri so and so had asked the Chief Secretary to convene a meeting of the cabinet and to place the show cause notice dated 26/7 and all other materials before the cabinet. Accordingly, the cabinet meeting was convened on 1/8/1918, wherein show cause notice dated 26/7 and other materials were discussed, and the aforesaid resolution dated 1/8/2024 came to be passed. I have also taken note of the fact that the said cabinet meeting was not presided over by Sri Siddaramaiah, the Chief Minister. So it only narrates what the cabinet has done. In the present case, the petitions have been filed seeking grant of sanction against Sri Siddaramaiah. The resolution dated 1/8 of the cabinet has been passed by the cabinet colleagues of Sri Siddaramaiah, who have been appointed on his advice. In view of the above, and considering the fact that the petitions have been filed seeking sanction for investigation and prosecution against Sri Siddaramaiah, Chief Minister, I have also independently examined the petitions and documents submitted in support of the same, not the representation of the same. Now, since the sanction is sought against Chief Minister himself, the surrounding circumstances of placing the show cause notice and the decision of the cabinet would not inspire confidence to act on such advice. So it is about cabinet advice. Para 9. Subject of binding of the advice, again it quotes the cabinet this thing. And quotes Madhya Pradesh police establishment case. That is it. Then para 10. This is where a decision is taken.
Upon perusal of the material.
Upon perusal of the petition, sir, not material.
Petition along with the material.
Along with materials in support of the allegations in the petition and subsequent reply of Siddaramaiah and advice of the state cabinet along with the legal opinion, it seems to me that there are two versions in relation to the same set of facts. It doesn't spell out what are those two versions. it is very necessary that a neutral, objective, and non-partisan investigation should be conducted. I am prima facie satisfied that the allegations and the supporting materials disclose commission of offences. Nearly 25 offences are cited.
Ah.
Which of those offences? For example, forgery is alleged. Is it the case that the governor is satisfied that chief minister has forged?
This is the first question I asked him the other day. Anyway,
Yes.
he will answer.
Yeah. So, my very respectful submission, is this is not consideration of the representation. And the, very interestingly, the note is important. That's why I was reading para 31 in the note. So this is all what the order says.
Order says, the governor's note is there.
Governor's note
Yes,
alle,
yes.
para 31 allu.
Yes, yes. Hmm. You can read, yes, sir.
Yes.
Hmm.
In view of the averments made in the aforesaid petitions, seeking grant of sanction for prosecution and the materials in support of the same, subsequent issues of show cause notice dated 26, reply to the show cause notice of by Sri Siddaramaiah dated 3/8, legal opinion of the learned Advocate General, and the decision of the Council of Ministers. I am of the opinion. So considering all this, what is the opinion formed? I am of the opinion that in exercise of my powers under Article 163(1), considering the aforesaid material placed before me and the facts and circumstances of the present matter, as a matter of propriety, I shall exercise my discretion by independently examining the aforesaid material. So he now proceeds to examine. What does he examine? 31.1. It is seen from the resolution of the Council of Ministers. The conclusion has been arrived at by the Council of Ministers by non-consideration of relevant material facts. For instance, the Council of Ministers has taken into consideration that absence of possession notification or a measure taking possession was mandatory.
Yes.
However, the revenue transfer certificate as provided under Annexure A5 of the petition by T.J. Abraham clearly stated possession of the alleged land was with Muda. Further, the fact that the alleged land was developed, etc., I'll come to it later. So, governor is satisfied, possession is with Muda. Because Abraham says so, and cabinet advice to the contrary is rejected for that reason.
So documents are there.
I'm obliged.
Muda's name is there everywhere.
I'm
That is what
deeply-
is said.
I'm deeply obliged for that. Kindly come to documents of Abraham.
Three ಕೊಡಿ.
90 minutes governor has heard. I think this was the only pertinent question he should have asked. Kindly come to para 51.
Para 51.
Sorry, page 51. This is Abraham's petition. which-
Objections.
No, Abraham's application, sorry,
Complaint.
Complaint, which starts at page Annexure B, page 48.
Sorry.
I'm sorry. ಗಡ್ಬಿಡಿ ಆಯ್ತು.
ಅಲ್ಲ, ಇಲ್ಲಿ file with.
Page 48,
Yes.
Annexure B.
You are referring to the complaint of T.J. Abraham.
Yes, R3.
That is found in which,
This is what the learned, I mean,
no, you're
the
reading the
index-
governor's note or the
no, governor's note refers to Abraham's contention.
complaint?
Complaint,
That is page 50.
page 48, Annexure B.
48 it starts, annexure B.
Ah.
Yes, sir.
Yes. Now kindly come to page 51.
Hmm. Yes.
Award declared,
Hmm.
page 51. On 30th March 1998, subsequent to the notification dated 20th August 1997,
Ah.
the preliminary award notice dated 20th August 1997, the award decision notice dated 12/3, and the final award notice indicating award of 3,24,000 was issued on 30/3 to Ninga, son of Javra. Sir, Ninga is dead 28 years ago.
But the award notice refers to Ninga.
It is issued in his name.
Yes.
It is issued in name. A copy of the preliminary award notice, the award decision, etc., are produced. Then immediately, next sentence, he stumbles conclusion. Possession with Muda. As a consequence of the notification, the entries for the year 98-99 in the RTC indicates that the said lands were in the ownership and possession of Muda, effectuated by so and so. Now the question is, when was the possession taken over by Muda? He doesn't say so. Why he doesn't say so, I will refer to it. Kindly come to Annexure B1.
No, possession was taken over by Muda. No, he may say or is not said. But does the fact remain that possession was taken by Muda after the preliminary notification, final notification, award notice, then Muda is in possession. Everywhere it is said Muda is in possession.
I am obliged.
Symbolic
Kindly
or
come.
physical.
I am obliged for that also.
Yes.
Kindly come to Annexure B1.
That's the annexures that were read out earlier.
Sir, this has been suppressed. I'll point out.
What has been suppressed?
The fact that possession was not taken.
Where is the document?
I'll show that. Kindly come to Annexure B3.
D3.
B3. Page 105. This is the crucial document. I request the court to kindly permit me to read.
Yes,
It's a very
yes.
short document.
Yes, yes. Award notice.
This is award notice.
Yes.
Under Section 12(2)
Yes.
of the Land Acquisition Act.
Yes.
So everything is addressed. Ninga as
Ninga.
court observed. It
Yes.
is Ninga Uruf Javra. Property name is correctly described. No problem. Kindly come to the narrative at the bottom of the page. ಮೇಲ್ಕಂಡ ಸ್ವತ್ತಿಗೆ ಅವಾರ್ಡ್ ಆಗಿರುವ 3,24,700 ರೂಪಾಯಿ ನೀವು ಈ ಆಫೀಸಿಗೆ 15/4/98 ಬೆಳಿಗ್ಗೆ 11 ಗಂಟೆಗೆ ಈ ಜಮೀನಿನ ದಾಖಲಾತಿಗಳ ಸ್ವತ್ತಿನ ಮೇಲಿನ ಕಂದಾಯ ವಗೈರೆ ಪಾವತಿ ಮಾಡಿರತಕ್ಕ ದಾಖಲಾತಿಗಳು ಹಾಗೂ ಈ ಸ್ವತ್ತಿನ ತಹಲ್ವರೆಗಿನ 13 ವರ್ಷದ ಬಾಬ್ತು ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಅವರ ಎನ್ಕಂಬ್ರೆನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಸಮೇತ ಹಾಜರಾಗಿ ಮೊಬಲಗು ಪಡೆಯತಕ್ಕದ್ದು. ಮೇಲ್ಕಂಡ ಸ್ವತ್ತು ಪ್ರಾಧಿಕಾರದ ಕೆಲಸಗಳಿಗೆ ಬೇಕಾಗಿರುವುದರಿಂದ ಅದನ್ನು ಈ ನೋಟಿಸು ತಲುಪಿದ ಡ್ಯಾಶ್ ದಿನದೊಳಗಾಗಿ ಅದು ಕೂಡಲೇ ಇರಬೇಕು. ಐ ಡೋಂಟ್ ಗೆಟ್ ದಿ ಇಟ್ ಈಸ್
ತಲುಪಿದ ಕೂಡಲೇನೆ.
ಕೂಡಲೇ ಇರಬೇಕು.
ಎಸ್.
ಕೂಡಲೇ ದಿನದೊಳಗಾಗಿ ಖುಲಾಸು ಮಾಡಿ ಇಲಾಖೆ ಮಜುಕೂರಿಗೆ ಒಪ್ಪಿಸಿಕೊಡತಕ್ಕದ್ದು. ವೆಕೇಟ್ ಮಾಡಿ ಪೊಸೆಷನ್ ಸರೆಂಡರ್ ಮಾಡಿ ಅಂತ. ತಪ್ಪಿದಲ್ಲಿ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಷನ್ ಕಾಯ್ದೆ 16ನೇ ಸೆಕ್ಷನ್ ಮೇಲೆ ಸ್ವತ್ತು ಸ್ವಾಧೀನಕ್ಕೆ ತೆಗೆದುಕೊಳ್ಳಲಾಗುತ್ತದೆ. ಕೈಂಡ್ಲಿ ಮಾರ್ಕ್ ಇಟ್. ಸೊ ದಿಸ್ ಈಸ್ ದಿ ನೋಟಿಸ್ ಡೈರೆಕ್ಟಿಂಗ್ ಹಿಮ್ ಟು ಸರೆಂಡರ್ ಪೊಸೆಷನ್. ಅಲ್ಲದೆ ಇತ್ತೀಚಿನ 3 ವರ್ಷಗಳ ಎಟ್ಸೆಟ್ರಾ ಅದೇನು ಬೇಡ. ಸೊ you surrender possession immediately. When was this served and on whom it was served? It was served on one son, Mallayya. It was served on 18/4/1998. 15/4 ಬಂದು ದುಡ್ಡು ತಗೊಂಡೋಗಿ ಅಂತ ಕೊಡೋ ನೋಟಿಸು 18/4 ತಲುಪುತ್ತೆ.
4 days ಅಲ್ಲಿ.
ಅಲ್ಲಲ್ಲ, ಅದೇ ಆ ಇವೆಂಟ್ ಆಗೋದ್ಮೇಲೆ, ಆ ಡೇಟ್ ಆಗೋದ್ಮೇಲೆ ತಲುಪುತ್ತೆ.
ಹಾಗೆ.
ಸೊ ಅವ್ನು ದುಡ್ಡು ತಕೊಳ್ಳೋದ್ ಸ್ಕೋಪ್ ಇರ್ಲಿಲ್ಲ 18/4. ಸೊ ಅವನು ಅದ್ರಲ್ಲಿ ಹೇಳ್ತಾನೆ ನಿಂಗ ಪಾವತಿ ಆಗಿರೋದ್ರಿಂದ ನಾ ತಗೊಳ್ತೇನೆ ಅಂತ. ಬಿ ದಟ್ ಆಸ್ ಇಟ್ ಮೇ, ಅದು before he was dispossessed, either he should have surrendered thereafter and there should have been a measure. Not a scrap of paper is produced by them to say that any such measure was conducted or possession was taken. Much less any details are given as to when and where, by whom possession was taken over. Now, after the award notice, immediately within a month thereafter, denotification happens. That is at page 110,
Yes.
18.5.
18/5/1998.
Yes.
Hmm.
It is gested on 4/6.
Page?
Page 110, Annexure C. ಇವತ್ತು
Okay.
ಕೊಟ್ಟಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲೂ ಇದೆ ಅದು ಅಲ್ಲ ಇವತ್ತು ಫ್ರೆಶ್ ಆಗಿ ಕೊಟ್ಟಿರೋದ್ರಲ್ಲೂ
ಅದರಲ್ಲೂ ಇದೆ. Those
ಅದ್ರ-
documents have.
ಹಾ.
It's a compilation of all.
ಎನಿವೆ ಇದು ದಿಸ್ ಇಸ್ ಡಿನೋಟಿಫೈಡ್ 464 ಕನ್ನಡದಲ್ಲಿದೆ. ಕನ್ನಡ ಅಂಕಿಗಳು
Hmm.
ಪೇಜ್ 111.
The government takes a decision to denotify?
Yes,
Yes. All right, government order. Notification.
yes, government notification and it's a gazette notification and it is pursuant to the deliberations of the committee which my learned friend Dr. Singhvi has already highlighted. Now, very important to take note here is that after the denotification, no further development has taken place. Possession was either asked or pursued after the denotification. Obviously,
But layout is formed, everything is done.
ತಾವು ಹೇಳ್ತೇನೆ ಒಂದು ನಿಮಿಷ.
ಅಲ್ಲ, no development has
acquisition
taken
act.
place.
ಅಲ್ಲಲ್ಲ, ಒಂದು ಲ್ಯಾಂಡ್ ಅಕ್ವಿಷನ್ ಆಕ್ಟ್ ಒಂದು ನಿಮಿಷ ತಾವು ನೋಡಿದ್ರೆ
ಕೊಡಿ.
ಸೆಕ್ಷನ್ 48.
Yes, denotification.
Yes.
Yes.
Act.
48 ಓದಿ. Yes. ಇದು ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ ಅಲ್ವಾ, ಅದಿರಲ್ಲ. ಅದಕ್ಕೆ ಓದಿ ಅಂತ ಹೇಳಿದ್ದು ಅದಕ್ಕೆ. 482 ಕೋರ್ಟ್ ಅಲ್ಲಿ ಲ್ಯಾಂಡ್
ಇಲ್ವಾ?
ಅಕ್ವಿಸಿಷನ್
ಇಲ್ದೇ ಇದ್ರೆ ನಾನು
ಇಲ್ಲ ಅಂತಾನೆ ಅದಕ್ಕೆ ಹೇಳಿದ್ದು, ಅದಕ್ಕೆ ಓದಿ ಅಂತ ಹೇಳಿದ್ದು.
on section 48,
Yes.
1. Except in the case provided for in section 36, this does not come under that. The government shall be at liberty to withdraw from the acquisition of any land. Kindly mark the next phrase, very important. That's a condition precedent of which possession has not been taken.
Yes. At that time aware.
Sir, this is
48
condition precedent. When there is a notification and I have shown that no possession was taken, how can the governor come to the conclusion there is a possession with the Muda? How can the complainant misrepresent to the governor?
Is it not that once final notification is issued and award is passed determined, it vests with the government?
Sir, vesting is different from possession,
All right.
with great respect.
Yes.
Otherwise, why would notice be given? More importantly, kindly permit me to show that under section 16, they are entitled to take possession.
Yes. The
Six-
Land Acquisition Act. ಅದೇ
Six-
ಸರ್ಗೆ ಕೊಟ್ಬಿಡಿ.
ಬಂತಾ? 16,
ಇದು ಬರಲ್ಲ, ಐದುವರೆ ಆಗೋಗಿದೆ.
16(1). ತಾವು ಒಂದ್ ನಿಮಿಷ ನೋಡ್ಬಿಟ್ರೆ. Possession has to be taken under section 16(1).
Yes, sir.
And it is very well established that possession has to be taken by drawing a measure.
Yes, that is.
No such measure has
There is
been,
no measure drawn.
no measure drawn whatsoever.
Yes.
So 16(1) possession is not taken.
So the submission is, it's still vested, still the land was in possession of the legal heirs of Ninga.
It continued to be a
Continued to
private
be-
land,
Continued to be a private.
private land.
Therefore, it was not a
And,
subject.
and this was conclusively established when a 16(2) notice, 16(2) ತಾವು ಒಂದ್ ನಿಮಿಷ.
Yes,
16(2) notification was issued.
yes.
That notification we have placed before the court today, which is a gazette notification.
Hmm.
So if possession is taken, It will be notified in the Gazette under subsection 2 of section 16.
16, yes.
Sir, ತಾವು ಇವತ್ತು page 53
ಇವತ್ತು ಕೊಟ್ಟಿರೋದ?
ಇವತ್ತು ಕೊಟ್ಟಿದ್ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಡಾಕ್ಟರ್ ಸಿಂಘ್ವಿ
ಇಲ್ಲ, yes.
document number 12, page
Yes.
53.
All right.
ಸೊ ಇದರಲ್ಲಿ ಕೆಸರೆ ಗ್ರಾಮ ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲೇ ಬರುತ್ತೆ. ಕೆಸರೆ ಗ್ರಾಮದ ಅಕ್ವೈರ್ಡ್ ಲ್ಯಾಂಡ್ಸ್ ಎಲ್ಲ ಎನ್ಯೂಮರೇಟೆಡ್ ಆಗುತ್ತೆ 1 to 24.
ಹ್ಮ್.
ಇದರಲ್ಲಿ 464 ಬರಲ್ಲ.
ಹ್ಮ್.
ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ in seriatim the survey numbers are mentioned. Kindly come to item 34, which is 455.
ಹ್ಮ್.
455 ಆದ್ಮೇಲೆ 464 ಬರ್ಬೇಕಿತ್ತು.
ಹ್ಮ್.
466 ಕೊಟ್ಟೋಗ್ತಾರೆ.
ಹ್ಮ್.
ಯಾಕೆಂದ್ರೆ 464 ತಗೊಂಡಿಲ್ಲ.
ಹ್ಮ್.
ಅದಾದ್ಮೇಲೆ ಎಲ್ಲೂ 464 ಬಂದಿಲ್ಲ.
What is document 13?
13.
ವೈಯಕ್ತಿಕ ಅವಾರ್ಡ್ ಡಿಟರ್ಮಿನೇಷನ್.
ಅವಾರ್ಡ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಪೊಸೆಷನ್ ಅಲ್ಲ.
ಅಲ್ಲ, ಅವಾರ್ಡ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದೆ.
ಕೊಟ್ಟಿದ್ದಾರೆ. ಐ ಡೋಂಟ್ ಡಿಸ್ಪ್ಯೂಟ್ ಅವಾರ್ಡ್ ನೋಟಿಸ್.
ಅಲ್ಲ, ಆಫ್ಟರ್ ಡಿನೋಟಿಫಿಕೇಶನ್ 15 to 1999.
I request the court to kindly mark one thing.
That's what, yes.
What happened was, now this notice was taken out on the basis of the common award that was made. I think common award is also produced.
ಅದೇ ಕಾಮನ್ ಅವಾರ್ಡ್ ಓದಿದ್ದೆ ಅವಾಗ್ಲೇ.
ಹಾ.
Yes.
Common award. Page 29 ಅಲ್ಲಿದೆ. Yes. Page 29 ಅಲ್ಲಿ it is dated 31/10/97.
Yes. After the final notification.
464 is specifically mentioned in line number 4.
Yes.
ಕೆಸರೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ಗಳು.
ಆಮೇಲೆ ಅದಿರಲ್ಲ.
ಸೊ ಇದಕ್ಕೆ ಅವಾರ್ಡ್ ಆಗಿದೆ. ಕಾಮನ್ ಅವಾರ್ಡ್ ಅಲ್ಲಿ ಇದು ಜನರಲ್ ಅವಾರ್ಡ್ ಅಲ್ಲಿ ಆಗಿದೆ.
ಅದಕ್ಕೆ
ಹಾಗೆ
ಡೆಪಾಸಿಟ್ ಮಾಡಿ
1,52,00,000 ಟೋಟಲ್ ಅವಾರ್ಡ್ ಎಲ್ಲದಕ್ಕೂ ಸೇರಿ.
ಕಾಮನ್ ಅವಾರ್ಡ್
ಎಲ್ಲದಕ್ಕೂ ಸೇರಿ ಈ ಅಮೌಂಟ್ ನ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಪಾಸಿಟ್ ಮಾಡಿ.
ಹೌದು.
ಅಂಡ್ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಏನ್ ಮಾಡಿದೆ, ನೀವು ಈ ತರ ಲಂಸಮ್ ಕೊಟ್ರೆ ಆಗೋದಿಲ್ಲ, ಇಂಡಿವಿಜುವಲ್ ಆಗಿ ಪ್ರತಿ ಲ್ಯಾಂಡ್ಗೂ ಕೊಡಬೇಕು ಅಂತ. ಇನ್ ದಿ ಇಂಟ್ರೆಗ್ನಮ್ ತಾವು ತೋರಿಸಿದ್ದು ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್ 13 ಬಂದಿತ್ತು. ದಿಸ್ ಇಸ್ ಬೇಸ್ಡ್ ಆನ್ ದಿ ಕಾಮನ್ ಅವಾರ್ಡ್, ಬಟ್ ದಿಸ್ ಇಸ್ ನಾಟ್ an independent award. Be that as it may, he has not drawn that amount. No compensation was paid. It is nobody's case that compensation was received.
was not claimed.
Not claimed, not paid.
Deposited in civil court, not
Returned. No. What was deposited has been returned.
All right.
And that has lapsed.
That is 3,24,000.
No, entire amount was deposited for the
ಅಲ್ಲ, page 60 ಪರಿಹಾರ ವಿವರ.
ಪರಿಹಾರ ವಿವರ ಅವರು
ಅದು
ಅದನ್ನ
ನಿಮ್ದು.
ಹೌದು, ಅದು ಕೋರ್ಟಿಗೆ ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ದಲ್ಲ. ಎಂಟೈರ್ ಅಮೌಂಟ್ ನ ಒಟ್ಟಿಗೆ ಡಿಪಾಸಿಟ್ ಮಾಡ್ತಾರೆ. ಅದು ಡೀಟೇಲ್ಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಇಲ್ಲ, ವೈಯಕ್ತಿಕ ಅವಾರ್ಡ್ ನಿರ್ಣಯ ನಿಮ್ದೇ ಅದು.
ಅವಾರ್ಡ್ ಬೇಸ್ಡ್ ಆನ್ ದಿ
ಕಾಮನ್ ಅವಾರ್ಡ್,
ಜನರಲ್ ಅವಾರ್ಡ್.
All right.
ಎವ್ರಿ ಒನ್ ವಾಸ್ ಈ ತರ ನಿಮಗ್ ಬರುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರು, ತಗೊಂಡೋಗಿ ಅಂತ ಹೇಳಿದ್ರು, ತಗೊಂಡೋಗಿಲ್ಲ. ಸೊ ದೇ ಡಿಪಾಸಿಟೆಡ್ ಇಟ್ ಅಂಡರ್ section 31.
No, these are all events that have happened earlier. You come into the picture in 2004, or the family comes into the picture in 2004.
No, with great respect, court heard them per over a day. That where is the land?
Everybody over a day.
Allala, where is the land? Where is the village? I am answering that question.
All right, yes.
Where is the land? Sir, land is with me. My predecessor in title. It has never left my hand. It is still with me I am the owner, I am the man in possession.
Then how did Muda form layout in that?
Yes, that is the $1 million
If
question.
you knew that you were in possession of the land and it was conspicuous,
Yes,
then how did you permit Muda to form a layout there?
my permission is needed.
No, no, ಆಗಲ್ಲ.
ಅಲ್ಲಲ್ಲ,
You
ತಾವು
should have
ಕೇಳೋದ್ ನೋಡಿದ್ರೆ
objected
ನಾನು
to it.
ಪರ್ಮಿಷನ್ ತಗೊಂಡ್
Well,
ಮಾಡ್ತಾರೆ.
you have not objected to it any time.
No,
but
no,
this
with
is
great
land.
respect.
How
No,
are you
no,
forming a layout?
why should I object
Need not
when,
object.
when the layout plan excluded this particular land?
But even then, land layout is formed in your land.
May ಇದು plans ಇದೆಯಲ್ಲ? ಇದೇನು? Yellow.
So anyway, the family comes into picture in 2004. Let's
Sir,
fast let's
kindly come
fast
to page
forward it to
52.
there.
Kindly come to page 52.
50?
52. ಇದು ಬೇರೆ ಫೈಲ್ ತಂದಿಲ್ವಾ? ಇದೆ ನೋಡಿ, ತೆಗಿರಿ. ಎಲ್ಲೋ ಫೈಲ್ ಒಂದಿದೆ. Page 52. Marked portion in page 52, the layout plan expressly declares that this is a denotified land.
Yes.
So this was not included in the layout. It was left out. And I have the copy of the approved plan. I'll give it. There also, the survey numbers which are being subjected to the development are also specified. 464 is left out. So this was not part of the layout. So in these circumstances, the land has never left the
Hands of Devraj.
Devraj. It remained with him. He sold it in favor of my brother-in-law.
Then comes the
Yes.
family. into the
That
picture.
learned senior counsel has already covered. I will not trouble the court.
So ಈಗ layout form, what is that?
The need of suspicion.
ಅಲ್ಲ,
ಅಲ್ಲ,
schemes.
the reason why I'm now the governor
Need of
proceeds.
suspicion.
The governor proceeds on the footing that possession is taken over. And my learned friend, Mr. K.G. Raghavan, eloquently argued the need of suspicion. ತಾವು ರಿಪೀಟೆಡ್ಲಿ ಕೇಳಿದ್ರಿ ಏನು ಇವ್ರ ರೋಲ್ ಏನು ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಅದಕ್ಕೆ ಯಾರು ಉತ್ತರ ಕೊಡ್ಲಿಲ್ಲ. ದಿ ನೀಡ್ ಆಫ್ ಸಸ್ಪಿಷನ್ ಇರೋದ್ರಿಂದ ತಾವು ಅದಕ್ಕೂ ಹೇಳಿದ್ರಿ ಹೇರ್ ಸ್ಟ್ಯಾಕ್ ಅಲ್ಲ ಅಂತ ಅಂದ್ಬಿಟ್ಟು. ಸೊ ದಿ ನೀಡ್ ಆಫ್ ವೇರ್ ಇಸ್ ಸಸ್ಪಿಷನ್ ಸರ್? ವೇರ್ ಇಸ್ ಪೊಸೆಷನ್? ಇಟ್ ಈಸ್ ವಿತ್ ಮೀ. A false statement is being made in the complaint that possession is with Muda. Governor records a perverse finding that the possession is Muda, and the entire case is built up on that foundation. The possession has never been handed over. The taking over of the possession is not even notified under section 16(2). And the layout plan, I'll place the certified copy. ಇದರಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿಲ್ಲ.
All right.
So the land is very much there. It remained an agriculture land till it was converted.
Till it was converted.
Yes.
Which is this layout scheme that Muda formed?
That's what I want to place it. ಇದನ್ನೇ ತಾವು
A
ನೋಡಿದ್ದು.
layout scheme was formed even in 464.
No. No.
All right.
I'm going to place the official plan,
All right.
approved plan.
So according to you, in 464, no layout.
It was
plan
not part of the layout. It was specifically excluded as a denotified land. And the number of the survey numbers were specifically enumerated. This was not included in the survey numbers that formed the project layout. I'll place it before the court.
All right, no problem. Yes, we'll take your statement.
So the entire case is built on this. Muda has taken over possession. Muda has developed the land. And that is the finding recorded by the His Excellency the Governor. So this is the foundation for the Governor's order. Kindly permit me to resume the
Yes.
reading of it,
Back to the,
it makes further interesting.
bring back to the governor's. thought,
Back to the
yes.
governor.
Yes.
ಅದನ್ನೆಲ್ಲ ಯಾತಕ್ಕೆ ಹೇಳ್ತಾರೆ ಅಂತಂದ್ರೆ ಲಾಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಇನ್ 31.1 ಅಂದ್ರೆ ಪೊಸೆಷನ್ ತಗೊಂಡಿರೋದು. The aforesaid aspect have not been examined and considered by the Council of Ministers.
That is why he terms it to be irrational.
Possession. So it is about, it is a comment on the Council of Ministers advice. Now kindly come to para 31.4.
Hmm.
In the present matter, page 18.
Yes.
In the present matter, the allegations and the material in support of the allegations would prima facie indicate that the said land was given to a SC person due course of law.
Yes.
The records of the said land was transferred from the father to the children
Hmm.
and again from children to father. So this is a fantastic story of the governor. Where is it?
Children to father.
Ah. This is what governor has written.
So the
Kindly,
Father was not there by.
kindly see the. ಅಲ್ಲ ಇದು ಬುರುಡೆ ಬಿಡ್ತಾ ಹೋದ್ರೆ ಅದಕ್ಕೆ ರೈಲ್ ಇರೋದಿಲ್ಲ, ಹಳಿ ಇರೋದಿಲ್ಲ, ಹಿಂಗೆ ಹೋಗ್ತಾ ಇರುತ್ತೆ. Kindly see para 31.
That I have seen.
Yes. So the records of the land was transferred from father to children, again from children to father, and this mystery was considered by the state cabinet, was not considered by the state cabinet. How should they imagine that this kind of a story would be written in the governor's order? They would have considered it. So this is the first reason. When the notification for land acquisition issued and the notification order was issued, Siddaramaiah was the MLA, etc., etc.
Is on the.
Yes, yes. Now all this, why is he saying all this?
Power timeline of the chief minister.
No, all this, why is he stating? Kindly come to the bottom of that paragraph. Due to the apparent bias, the present matter requires my independent application. Now, Shivbhaktan kate heladnalla. Cabinet advice, bari cabinet advice baggene he is obsessed. So, it is biased. Next also, 31.5. Again, he is on the cabinet advice. Cabinet Council of Ministers, the Council of Ministers do not consider the entire material in support of the allegation. 31.6.
Yes.
He quotes the Madhya Pradesh case.
Hmm.
I request the court to kindly permit me to read 31.8.
Hmm.
Dr. Singhvi has elaborately argued.
Yes.
But only one aspect I would like to. Very, very disturbing finding has been recorded by the governor in para 31.8. In view of the aforesaid, it emerges that the present situation amounts to peril to democratic principles. Sir, in the last 50 years, kindly take judicial notice of this fact. Siddaramaiah is the only man who has served full term of 5 years. And he is now re-elected. And the governor has this thing to say that democracy is in peril. He is a nominated governor. An elected man with such an overwhelming mandate, a man who has ruled the state without any blemish. I request the court to kindly take it. Is it not a disturbing finding that the governor has indulged in? Kindly look at the predecessors who ruled the state. What has happened to them? What kind of situation they have faced? And a man who has been in power for such a long time, ಒಂದು ಜುಜ್ಬಿ ಸೈಟ್ಗೆ ಇಷ್ಟು ಇದನ್ನ ಮಾಡ್ಬೇಕಿತ್ತು. 23.
ನಿಮಿಷ. ಜುಜ್ಬಿ ಸೈಟ್ ಅಂದ್ರೆ
ಅಲ್ಲ, ಜುಜ್ಬಿ ಸೈಟ್ ಯಾಕೆ ಹೇಳ್ತೀನಿ ಅಂತಂದ್ರೆ, ಅಲ್ಲಲ್ಲ, ಜುಜ್ಬಿ
ಅಲ್ಟಿಮೇಟ್ಲಿ ಅದು ಹಾಗೆ ಆಗಿದ್ರೆ ಇವ್ರು ಏನು ಮಾಡ್ತಿರ್ಲಿಲ್ಲ.
ಅಲ್ಲಲ್ಲ,
55 crores
ಅವ್ರು
ಇದೆ
ಬೇ-
ಅಂದ್ಬಿಟ್ಟು ಅಷ್ಟೇ.
ಇಲ್ಲ ಇಲ್ಲ, ಸ್ವಲ್ಪ ಹೇಳ್ತೀನಿ ಕೇಳಿ. ಜುಜುಬಿ ಸೈಟ್ ಯಾಕೆ ಸ್ವಲ್ಪ ಸುಮ್ಮನೆ ಕೂತ್ಕೊಳ್ತೀರಾ?
Wait, sir.
ಕೂತ್ಕೊಳ್ಳಿ.
Yes.
ಜುಜುಬಿ ಸೈಟ್ ಯಾಕೆ ಹೇಳ್ತಾ ಅಂದ್ರೆ 60-40 ಅವ್ರ ತಕರಾರು ಇಲ್ಲ, 50-50 ತಕರಾರು ಇದೆ. ಅಂದ್ರೆ ಇನ್ನೆರಡು ಸೈಟ್ ಎಕ್ಸ್ಟ್ರಾ
ಅಲ್ಲ,
ಬಂದಿರ್ಬೋದು.
ರೇಷಿಯೋಗಲ್ಲ ತಕರಾರಿರೋದು.
ಹಾ,
The ultimate beneficiary to one roof that has gone, that is 55 crores is the problem. Anta, that is what they are
no, with
projecting.
great respect, it is in respect of her land.
It is what they are projecting.
No, 3 acres 16 ಗುಂಟಾಸ್ ವಾಪಸ್ ಕೊಡಿಸ್ಬಿಡಿ, ಮುಗಿದೋಯ್ತಲ್ಲ. Anyway, it is not a denotified land, admittedly.
Not a denotified land.
It is a denotified land.
Notified.
Denotified land. It ought not to have been subjected to layout formation. They have encroached and done it. ವಾಪಸ್ ಕೊಡಿಸ್ಬಿಟ್ರೆ ಮುಗಿದೋಯ್ತು. ಅವ್ರ ಲ್ಯಾಂಡ್ ಅವ್ರು ವಾಪಸ್ ಕೊಡಿ. ಅದಕ್ಕೀಗ ಇಷ್ಟು ಸೈಟ್ ಕಾಂಪನ್ಸೇಟರಿ ಸೈಟ್ಸ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದು ಕೊಟ್ಟಿರೋದು ಸಿದ್ದರಾಮಯ್ಯ ಅಲ್ಲ, ಅದು ಕೊಟ್ಟಿರೋದು ಮೂಡ. ಮೂಡ ಕೊಟ್ಟಿರೋದಕ್ಕೆ ಅದರದೇ ಆದಂತ ಒಂದು ಪ್ರೊಸೀಜರ್ ಇದೆ. ದೇ ಹ್ಯಾವ್ ಫಾಲೋಡ್ ಇಟ್. Sir, kindly take judicial notice of this fact. When one man is in power, so many things may be happening. Somewhere some of his relatives may be benefited. There may be officers who are overzealous. ಮಾಡಿರ್ಬೋದು, ಮಾಡಿಲ್ದೇ ಇರ್ಬೋದು. ಬಟ್ ಅದಕ್ಕೆ can you hold a man who is at the helm of the affairs, who is ruling the state with such popularity, subject him to this kind of cavalier treatment?
What has happened?
Sir, sanction.
Approval.
He says sanction.
ಅಲ್ಲ, ಅದು ಆಮೇಲೆ, that is.
ತಾವು ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿ ಅದನ್ನ ಅಪ್ರೂವಲ್, ಅವ್ರು ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡ್ತಿದ್ದಾರೆ ಅದು ಅಪ್ರೂವಲ್ ಅಂತ. ಅವರು he says it is a sanction. So this 31 point
So it is
itself,
not, it is not that the edifice is now shaken. It's approval.
no, 31.8, the finding there, it betrays the mind of the government. The political
We will answer.
political vendetta he has got in taking this decision. We have attributed
Yes, that
political motives,
I have seen.
and he has not refuted them by any affidavit. My learned colleague instructs me. There is absolutely no scam against him, and therefore they have brought up this.
I saw Billy doing it. Yes.
So
Yes.
it is in this state of affair. I request the court to kindly. So this is the needle of suspicion my learned friend was harping upon.
Needle that
There-
is now
there-
prick,
there
the
is-
needle that is now pricking.
There is no suspicion, there is no gray area. The possession is with me,
Hmm.
and therefore they have to compensate for having encroached upon it.
Yes, sir.
And
You have any judgments to?
I have
give?
already given Article 20, this thing. Now
Ah,
that,
that is, yes.
yeah, now
Post
that,
facto.
yeah,
Post facto with regard to
yes.
provisions under the BNS.
Now that they have considered,
ಅದು sanction 17A ಮಾತ್ರ ಈಗ.
ಈಗ 17 year. So I'll not further trouble the court
So
with
that,
either.
that may not be required. Post facto finding need not be gone into.
ಓದಿಲ್ವಾ? 17A ಗೆ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್
ಕೊಡಿ.
ಕೊಟ್ಟಿಲ್ವಾ? ನನಗೆ ಕೊಟ್ಟಿದ್ರಲ್ರಿ, ಕೊಡಿ. This is a case of Shankar Bhatt versus State of Kerala, 2021. ಇದೇ ತಾನೇ ಕೊಟ್ಟಿದ್ದು?
ಶಂಕರ್ ಭಟ್.
ಇದು ಕೊಟ್ಟಿಲ್ವಾ?
ಶ್ರವಣ್ ಕುಮಾರ್ ಅಂತೇನೋ ಇದೆ.
ಸರ್ ಇದು ಕೊಟ್ಟಿದೆ, ಆಗ್ಲೇ ಕೊಟ್ಟಿದ್ದಾರೆ, ಕಂಪೈಲೇಷನ್ ಇದೆ. ಸಾರಿ,
ನೋಡಿ,
I thought,
compilation ಅಲ್ಲಿ. ಶಂಕರ್ ಭಟ್ ವರ್ಸಸ್
ಕೊಡಿ, ಕಾಪಿ ಇದೆಯಲ್ಲ. ಕೊಟ್ಟಿಲ್ಲ, ಕಾಪಿ ಕೊಡ್ತೇನೆ ನಾನು. ಸಾರಿ,
ಇಲ್ಲ,
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಓದ್ಬಿಟ್ಟೆ ಕೊಡಿ.
ಹಾ.
ಇಲ್ಲ, ಐ ಆಮ್ ನಾಟ್ ಫೈಂಡಿಂಗ್ ಇಟ್ ಹಿಯರ್.
ಕೊಡ್ತೇನೆ.
ಇಲ್ಲಿ ಕೊಟ್ಟಿರೋದು
ಇದರಲ್ಲಿ
ಯಾವ್ದು
ಇಷ್ಟೇ
division bench.
ಅವ್ರು ಹೇಳೋದು ಸೆಕ್ಷನ್ 17A, ದಿ ಹಾರ್ಟ್ ಅಂಡ್ ಸೋಲ್ ಆಫ್ ಸೆಕ್ಷನ್ 17A is recommendation or a decision. That is, I'll
That
pass on.
statute ಅಲ್ಲಿ ಇದೆ.
Then. So with these submissions, I rest my case. Grateful to you. Yes.
ಅಷ್ಟೇನಾ? ನಿಮ್ದು ಇದೆಯಾ? It should not go on. It can't go on like.
ಕೆಸರೆ ವಿಲೇಜ್ ಬಗ್ಗೆ ನಾನು ಒಂದು ಹೇಳ್ಬೇಕು.
ಅದೊಂದು ಹೇಳ್ಬೇಕು. Because he says Kesare village is not there at all.
Sir, 2011 ಅಲ್ಲಿ ಸೆನ್ಸಸ್ ಮಾಡಿದ್ದಾರೆ.
Hmm.
And according to the census, I'll place the census report also. But I can give the data, census data. According to the 2011
Hey,
census,
why all of you have got up? Sit down. Yes.
ನಂದು ಇದೆಲ್ಲಿ list of dates. Not only Kesare village is intact, but Kesare village consists of several schools ಇದೆ, hospitals ಇದೆ, over 2000 acres land ಇದೆ Kesare village ಅಲ್ಲಿ. Now of course it forms part of the
That
Muda-
scheme.
city corporation.
ಅದೇ. Now
It
in
has
the
come-
MCC.
Yeah.
Yes.
I'll place that data. That
Your Lordship, just a
Kesare
short-
village was subjected to census 2011 ಅಲ್ಲಿ. Full data is available, entire population data.
That's the last census.
And the lands particularly, Kesare village ಕಳ್ದೋಗ್ಬಿಟ್ಟಿದ್ರು, ಕಳ್ದ್ಬಿಟ್ಟಿದ್ರು. I want to show,
Submission was made.
Yes.
Yes.
therefore I'll place it.
With your Lordship, can just a short note, my lord, on just with regard to prerequisite of prior to 17A, my lord, just a short note. I'll just give the submission.
Prerequisite.
Your Lordship, make only three issues which I have dealt with, my lords. First one is with regard to preliminary inquiry to determine the commission of a cognizable offence is a prerequisite for seeking prior approval under 17A. So therefore, my lords, prior to filing an application under 17A, my lords, a preliminary inquiry as per Lalit Kumari lines of judgment. I was not speaking about preliminary inquiry under 17A. Pre-17.
That's
The second issue is section 17A of the Prevention of Corruption Act does not provide for preliminary inquiry by the competent authority as provided under 173, my lords. Because what is required under 173,
according to you, preliminary inquiry is also by police officer.
please, my lords.
That's right. All
So,
right.
so therefore, it does not contemplate 173 inquiry by the competent authority. Because what is the nature, it's only a prior approval of the material as per the SOP, my lords, which is to
That's
looked into while deciding, my lords.
page 704.
Please, my lord. The last issue is when an investigation officer forms an opinion of a cognizable offence, the standing operating procedure dated 3rd September 21 requires submission of information or data in the form of the proposal to the competent authority in order to seek prior approval under section 17A of the PC Act for conducting inquiry or investigation. So therefore, my lord, what is required is that report, my lords, for which prior approval is given as for the prerequisite. So therefore, my lord, if that is not there, my lord, it is premature in that sense, my lords, to
Is premature.
the application to consider 17A.
ಯಾವಾಗ ಕೊಡ್ಬೇಕಾಗಿತ್ತು ನಿಮ್ಮ ಪ್ರಕಾರ?
So it would have been, ought to have been given if there was a preliminary inquiry pre-17A, or in the event worst scenario, my lords, if the competent authority, assuming, my lords, in the case it was not a governor, otherwise every competent authority will become an investigating officer while giving sanction. my lords.
Approval.
Prior, I stand corrected, prior approval. So therefore, my lords, he can't do the work of both preliminary inquiry of,
You told that the
so
other.
therefore, my
Both
lords,
can't do the work of the IO and competent.
and
authority.
competent, in support of that, my lords, only under 17A, my lords, and Lalit committed series of judgments, I put judgments which speaks about this situation.
No, one factor we must consider is when Lalita Kumari was rendered, statute ಅಲ್ಲಿ 17A ಇರ್ಲಿಲ್ಲ.
Please,
17A ಬಂದಿದ್ದು 2018 ಅಲ್ಲಿ.
correct.
So whatever is it Lalit Kumar, we immediately apply or who should conduct, is it all, it's a gray area
See,
still.
that's why my daughter Ashok's your lordship judgment, my lord. That's the only case which deals with private person, my lord.
Yes, private
That's-
complaint, that's the only.
That's the only case, and this is the next case which your lordships are dealing with 17A application, all that is prior to that. So the point is this, my lord, if preliminary inquiry is mandatory under 173(3) as well as per Lalit Kumari, if a cognizable offense is made out, my lords, by the IO, then 17A is an additional protection. It's an additional protection.
After cognizable offense is made out.
Please, my lord, that is what 17A says. 17A says no police officer, my lord,
Of a cognizable offense.
of a cognizable offense. So therefore, reading Lalit Kumari and 173(3), my lords. So therefore, my lord, the whole purpose of those line of judgments will be rendered odious, and again giving the power back to the competent authority to, the lordship may kindly forgive this case. Tomorrow, anybody, the minister or chief minister, that apart, any competent authority, any person can go give a complaint, he can
Anybody can set the criminal law into
no,
motion.
without, in case of protection under either
ಅದಕ್ಕೆ I have written 17A approval ಇಲ್ಲದೆ no man
Ah.
can set the criminal law into motion,
is-
que
que-
PC Act offenses.
correct. So therefore, 17A becomes premature.
Huh?
Because the same, like, if your lordship take it to its logical end, my lord, in that sense, 17A becomes premature unless that is done. So
Will consider.
that's all. I just.
ಅಲ್ಲ 5 ನಿಮಿಷ ಅಷ್ಟೇ.
Please, please.
Yes.
Since learned senior friend concluded with,
No new facts,
no, no, no.
only answering, yes.
Please,
5 minutes also, Your Lordship, closing.
ಹಾ, ಎಲ್ಲರಿಗೂ.
connection to the private complaint, my lord. It was concluded with how the court must deal, my lord, when a private complaint is.
ಇದು
placed with-
17A ಹೇಳಿದಾರ
How
ಇದ್ರಲ್ಲಿ?
the special.
17A ಹೇಳಿದಾರ?
17, please, please, very much.
Is after my judgment or before?
Division bench of the,
Madhya
Madhya
Pradesh.
Pradesh.
Yes.
please. I will invite my lordship's kind attention to page 16, my lord.
Hmm.
10.4, paragraph 10.4. Thirdly, section 17A does not bar the special court from conducting inquiry or inquiry as defined in section 2G of the Code of Criminal.
CRPs, yes.
Please. Argument may be raised that though the special court is not statutorily barred from conducting inquiry, but occasions may arise where the special court for aid and assistance may direct police to conduct inquiry, leading to an impasse in the face of statutory bar under section 17A, prohibiting police officer from proceeding ahead. True, it is that the police officer alone has been restrained from conducting inquiry or investigation, but the said argument can be put to rest by the well-established principle of law that what cannot be done directly in law also cannot be done indirectly.
As simple. Yes,
Therefore, please,
as simple as that.
please, my lord.
Yes.
So, my lord, I would, my lord, straight away draw my lord's kind attention to the operative portion, please.
This is
Uh,
exactly what is written.
Please, our
Yeah.
para 10.7. So the special court, my lord,
See, this is what others were doing. What could not be done directly by taking an approval under
Please.
17A?
please,
Go before the magistrate, get the matter referred, FIR registered, no 17A. That was being done indirectly.
Please.
That is why Ashok was
this is in
written.
conformity with Dr. Ashok.
Yes. ಆಮೇಲೆ
Now, my lord, my learned senior friend, my lord, made an assertion that the land, my lord, the possession was never taken. And so, it stood vested with the erstwhile owners. Lord, that is in fact self-contradictory to the claim made by the petitioners. Because she in her application, the two applications, my lord, dated 2014, another application dated 2021. She makes a claim that in the year 2001 itself, Muda has utilized survey number 464. Although, my lord, she or her family members were nobody at the relevant juncture, as observed by my lords earlier. Lord, then the claim itself becomes fraudulent, my lord. Now they say possession has never been taken. Now you come back to 2014 and say possession has been, the land has been encroached, possession has
No,
been
no,
taken
that
by
is
Muda.
in answer to your submission that possession is not taken at all.
Possession
ನೀವು
is-
ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರೆ ಆನ್ಸರ್ ಕೊಡ್ತಾನೆ ಇರ್ಲಿ.
Certainly, my lord. Now, the claim becomes fraudulent, because in the year 2001 itself, now they claim that the Muda had formed sites, parks, layouts, and other civic communities in the year 2001 itself. My lord, they cannot, my lord, make a claim contrary to their application, seeking. And interestingly, my lord, after a while, my learned senior friend makes a submission that encroach ಮಾಡಬಾರ್ದಿತ್ತು. Encroach ಮಾಡಿರೋ ಜಾಗಕ್ಕೆ, why did your brother-in-law go and seek for conversion? My lord, they cannot have a double standard approach, my lord. In fact, this is triple standard. Encroach ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಪುನಃ ಪೊಸಿಷನ್ ತಗೊಂಡಿಲ್ಲ ಅಂತ. Why did you go and seek conversion?
All right.
And they expect this honorable court to believe that by pursuance of a common man, Mallikarjunaya, that both Tahsildar and Deputy Commissioner of the concerned jurisdiction, they come to this spot, inspect and form an opinion that they have found and identified an agricultural land. When now, my lord, they say that the land was encroached. But kindly, my lord, this can be taken note
Land
of.
was encroached ಅಂತ ಹೇಳಿದ್ರು.
That is what they claim in the application.
Argument, submission ಏನ್ ಮಾಡಿ?
Yes. No, ಮಾಡಿದ್ರು.
All right.
That submission was made. Encroach ಮಾಡಬಾರ್ದಿತ್ತು, ಮಾಡಿದ್ದಾರೆ. That was made, my lord, in the open court.
No, that is the reason for asking compensation.
Please, my lord. So that being the case, my lord, now they cannot now, my lord, have multiple, my lord, approaches. Whether it was encroached or not, whether conversion was sought or not. That's the question, my lord.
ನಾವು ಕೊಡ್ಬೇಕು.
Please.
ಸಾಕು.
ಪ್ರಶ್ನೆ ಯಾರು ಕೇಳ್ತಿದ್ದಾರೆ ಅಂತ.
Lord, now I filed a written synopsis.
ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ?
Please.
ಕೊಟ್ಟಿದ್ದೀರಾ ರಂಗನಾಥ್?
Given. In fact, my lord said sought for the same, the earlier occasion.
Yes, sir.
Lord, in the year 1999, my lord, as observed by my lords, individual award came to be passed. It's
Sir,
not,
that is the document.
it's not as claimed as though a universal award was.
Common award was first passed.
Subsequently, it was.
ಆಮೇಲೆ
Please.
ವೈಯಕ್ತಿಕ ಅವಾರ್ಡ್ ವಿವರ ಅಂತ ಹೇಳಿ ಅದನ್ನ ಕೊಟ್ಟು ಅವಾರ್ಡ್ ಅಮೌಂಟ್ ಡಿಟರ್ಮಿನ್ ಮಾಡಿ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿ.
Please, please.
ಅಲ್ಲ, ಸಿವಿಲ್ ಕೋರ್ಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ.
Lord, when, my lord, the land was denotified, Lord, how could, my lord,
1998.
1998, after a year, my lord, the amount is deposited, the award amount. How could it be possible, my
No,
lord?
that is perhaps because of the common
Whether-
award ಅಂತ ಹೇಳಿ.
Whether such a denotification document is an afterthought and whether it is planted,
Sir, government notification after thought, gazette notification after thought ಎಲ್ಲಿಂದ ಬರುತ್ತೆ?
Lord, there are,
Amount has been returned by check. The
No.
amount.
ಆಫ್ಟರ್ ಥಾಟ್ ಆಗಕ್ಕೆ ಅದು ರಿಟರ್ನ್ ಆಗಿದೆಯೋ ಅಲ್ಲ ಬೇರೆ ಮಾತು. ಗಜೆಟ್ ನೋಟಿಫಿಕೇಶನ್ ಆಫ್ಟರ್ ಥಾಟ್ ಇರುತ್ತೆ. 99 ಆದ್ಮೇಲೆ 98 ಕೆನಾಟ್ ಕಮ್ ಆಫ್ಟರ್ ಥಾಟ್.
ಮೂಡಾದವ್ರು ಕೊಟ್ಟ ಇದು ಕಾಂಪನ್ಸೇಷನ್, ಇಟ್ ಹಸ್ ಬಿನ್ ರಿಟರ್ನ್ ಬೈ ಚೆಕ್.
ದ ರೂಟ್ ಆಫ್ ದ ಮ್ಯಾಟರ್.
ಕೊಡ್ತೇನೆ ಅದನ್ನ ಡೀಟೇಲ್ಸ್.
The AG always gets into the root of the matter.
my humble submission is, without, my lord, scrutiny, amount can never be deposited, my lord, in the jurisdictional court. That has been done. Now subsequently, my lord, initially, in the year 2014, my lord, after the application is made, the decision is taken, my lord, to, my lord, compensate the petitioner's wife in the ratio of 50-50, my lord, in a similar layout. Subsequently, another decision is taken after another 3 years, my lord, wherein decision has been taken to compensate her with a land which is undeveloped and in possession of Muda. Now, out of nowhere, my lord, the compensatory sites are allotted in upmarket Vijayanagar area, which is a posh locality, which is an upmarket area. Devanuru Badavane, my lord, can't be equated to Vijayanagara, just like Sadashiv Nagar of Bangalore.
In Vijayanagara?
Yes.
Oh.
In Mysore, that is the stature of.
I thought Jayalakshmipuram.
Not at all. Not at all.
All right.
Devanuru Badavane is like Chintamani.
Oh, all right.
So such is the.
I always knew that Jailpuram was equated to Sadashiv Nagar.
Such is the difference, my lord. Such is the difference between Devanuru Badavane and Vijayanagar. That apart, my lord, the special land acquisition officer, when he directs the petitioner's wife, my lord, he refers to certain meetings, my lord, of the year 2017 and of the year 2021. But when the allotment is made, out of nowhere, my lord, a meeting dated, a meeting of the year 2020 is referred to.
That nothing happened in that.
ಇಲ್ಲ,
Twenty
argue ಮಾಡಿಲ್ಲ.
21 meeting supersedes that 2020 meeting.
Please,
ಆ document ಇಲ್ಲ 2020.
he claims that in the year 2020 a decision has been taken and pursuant to that decision allotment has been made.
I don't, that resolution is not even there of 2020. I don't know what is that.
But it is there. my lord.
19/9/2020 ಅಂತೇನೋ ಇದೆ ಅದು.
ನಾವು ತಿರುಗಿ ರಿಪ್ಲೈ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ಇದು.
ಬೇಡ ಸುಮ್ಮನೆ ಇರಿ.
ನಾವು
Yes,
ಇಷ್ಟೆಲ್ಲ
ರಂಗನಾಥ್.
ಅವ್ರೆ.
ಅದೆಲ್ಲ ಹೇಳಿದೀರಾ ಸಿನಾಪ್ಸಿಸ್ ಹೇಳಿದೀರಾ ಐ ವಿಲ್ ಗೋ ಥ್ರೂ ಇಟ್.
Lord, my humble.
ಮತ್ತೆ ಇದಕ್ಕೆ ರಿಪ್ಲೈ ಅದೆಲ್ಲ ಆಗಲ್ಲ.
Page 178 to 194, my lord, the allotment letters are placed. Where
Allotment letters are placed, yes.
if at all, my lord, in the year 2020 itself, decision was taken to compensate the petitioner, right? Why would, my lord, she once again, my lord, approach the Muda with a letter dated 2021, my lord? Once again, another letter is written claiming compensation. My lord, these facts, my lord, would certainly, my lord, warrant investigation as to how.
ಅದು ಹೇಳಿ.
Please. Lord, lastly, my lord, coming to the antecedents, my lord, because there are some serious.
That you may have to reply.
Please, please.
ಅದನ್ನ ಮಾಡೋದ್ ಬಿಟ್ಟು ಇದೆಲ್ಲ ಬೇಕಾಗಿದೆ. ಇದೆಲ್ಲ ಹೇಳಿದ್ರಿ ಆಲ್ರೆಡಿ. What is the 25 lakhs? Because the submission is made, I have to answer that all.
Please. Sorry. The fine, my lord, was levied in connection to a PAL, my lord, preferred by the respondent number 3. Please. Lord, on the relevant day, he was, my lord, represented by his counsel, my lord. And at page 130, my lord, the operative portion, my lord, therefore, while discussing the SLP, we impose 25 lakhs. Now, thereafter, what happens is that, my lord, the petitioner, once again, my lord, he approaches the court and, my lord, explains as to, Lord, actually what transpired is that, my lord, it so-
Reduce costs,
Please.
amend the
it
application.
so happens, my lord, that the petitioner, my lord, he had entrusted his counsel with,
ಆಮೇಲೆ ಅದನ್ನ 1 lakh reduce ಮಾಡಿದ್ರ?
reduce ಮಾಡ್ತಾರೆ. In fact, they insisted on reduction. No, that, my lord, is nowhere told, my lord.
We asked for extension.
No, that's
In
why
fact,
I
we
said,
never sought for reduction.
sometimes whistleblowers face all this. It's
Please.
not that, yes.
Now, what happens is that, my lord, in fact, the brief, my lord, with the counsel on record at that relevant point of time, Ali, the file, my lord, would be of some other case.
No, that's all right.
Please.
It is reduced to 1 lakh.
Bona fide error was, my
That
lord,
is not a
appreciated.
problem. Then what is that outraging the modesty allegation?
Please, my lord. Now, page 77, my lord, may kindly be of the writ petition, of the statement of objections, my lord. Which I
ಏನ್ ಹೇಳಿ ಅದು?
please,
Which is that complaint?
my lord. In fact,
That PC Act complaint.
please, based on the complaint, my lord, of the respondent number 3, my lord, there were certain raids, my lord, which are taken place. Now, my lord, as a counter blast, there was a complaint, my lord, lodged against the respondent number 3. That, my lord, they are projecting as though the respondent number 3 is a convict. That is how, in fact, there are 2 cases, my lord, registered against the concerned complainant by the respondent number 3. And in fact, my lords is looking.
The other one, which was the other
Please,
day.
please. But paragraph E, my lord, page 77, my lord, of my statement of objection.
ಹೇಳಿ ಓದಿ.
Page 82, my lord. Lord, these are, my lord, the list of cases, my lord.
You have rebutted everything that is said in the petition.
Please,
Quay the antecedents.
please.
All right.
There's a separate paragraph, my lord, paragraph E.
All right.
Coming forth at page
Regarding
77.
paragraph AE.
E, my lord.
AE
Page 77, my lord.
77.
77, my lord.
Yes, yes. Regarding antecedents.
Please. Now, every allegation, my lord, is answered. Now, my lord, page 81 may kindly be perused. The mining case, my lord, which the respondent number 3 had approved it is still now, my lord, being directly, my lord, monitored by the Honorable Apex Court.
I know.
Please. And there are so many other cases which are,
That is why that statement was made.
please, Lord, in fact, at the risk of sounding political, my lord.
So don't sound political.
Kindly, my lord. Lord, in the last 2 decades, my lord, if the history of the state of Karnataka is seen, Lord, no political party, either be it the ruling party or the opposition party, they have uprooted either each other's scams or scandals, my lord.
Don't,
It is only these respondents,
See,
my lord,
these
risk
are
their
co-
life and limbs, my
the-
lord. They
these,
have, my lord.
we are in a court of law.
Please, please.
The argument should be apolitical.
My humble submission is,
Yes,
it is these private complainants, my lord. If the history is
I
seen,
told you again,
please.
I have made a statement that whistleblowers do suffer such things. It is not in the air made, yes.
No, my lord, because serious allegations could be made.
All right, you have countered that, I will consider, yes. Yes,
I'll submit that plan
ಅದ್ ಕೊಡಿ
uh,
sir.
so that they may also ಎಷ್ಟೊತ್ತಿಗೆ
ಅವ್ರು
ತಗೊಂಡು
ಮತ್ತೆ ಇನ್ನೊಂದು ಪ್ಲಾನ್
ಇಲ್ಲ no. I have already made my submission.
Yes.
That material I'll place before the court, the sanction plan and the census data.
ಎಸ್ ಮೇಡಮ್,
ನಾಳೆ ಎಷ್ಟೊತ್ತಿಗೆ ಅವ್ರು so that
ನಾಳೆ ಇಲ್ಲ ಮುಗೀತು ಇವತ್ತೇ.
ಅಲ್ಲ ಅವ್ರು ನಾಟ್ ಬಿಹೈಂಡ್ ದೇರ್ ಬ್ಯಾಕ್.
ಅಲ್ಲ, ಆತರ ಅವ್ರಿಗೂ ಕಾಪಿ ಕೊಟ್ಬಿಡಿ ಅಷ್ಟೇ. ಅವ್ರು ಕಾಪಿ ಕೊಟ್ಟು
Very well,
ಫೈಲ್ ಇಟ್
very
ಬಿಫೋರ್.
well.
ಐ ಆಮ್ ನಾಟ್ ಲಿಸ್ಟಿಂಗ್ ದಿಸ್ ಮ್ಯಾಟರ್.
ಇಲ್ಲ ಬೇಕಾಗಿಲ್ಲ, ನೋ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್.
ಎಸ್ ಸರ್,
ಐ ಥಾಟ್ ಐ
ನಾಟ್ ಫಾರ್ ಎನಿಥಿಂಗ್, ಲಿಸ್ಟಿಂಗ್ ಇಲ್ಲ.
ಓಕೆ,
ಎಸ್,
ವೆರಿ ವೆಲ್.
Page 33 may kindly be.
ಆಫ್ ವಾಟ್ ಸರ್?
Of my written synopsis.
ಸಿನಾಪ್ಸಿಸ್
Yes.
ಹೇಳಾಯ್ತಲ್ಲ ರಂಗನಾಥ್, ಮತ್ತೇನು?
Only couple of minutes, please.
ಹಾ ಹೇಳಿ. ಕಪಲ್ ಆಫ್ ಥಿಂಗ್ಸ್,
Only couple of minutes.
ಮಿನಿಟ್ಸ್.
Lord, regarding Lalita Kumari's case, my lord, what the court, in fact, in the learned AG had addressed this honorable court, my lord, that
ಅಲ್ಲ, ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ರೆಡಿ ಆಗ್ತಿರೋದು ನೋಡ್ರಿ 10:30 ಅಲ್ಲ, ಈಗ 6:30 ಆಗ್ತಾ ಇದೆ.
couple of
ಹಾ ಎಸ್ ಸರ್.
preliminary inquiry, my lord, not exceeding 7 days. There is clear, my lord, gap of 7 days, my lord, before.
ನಾನು ಐ ಟೋಲ್ಡ್ ದಟ್ ರೈಟ್. ಲಲಿತ್ ಕುಮಾರಿ ಸೇಸ್ ಒಂದು ವಾರದಲ್ಲಿ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಹೈಯರ್ ಆಫೀಸರ್.
Lord, all that, my lord, I want to say is that when Lalita Kumari was rendered, section 17A, my lord, was not in.
ಅದನ್ನು ಹೇಳಿದ್ನಲ್ಲ.
Please.
Ah.
Lord, because there are multiple, my lord, assertions made in connection to this.
We will answer.
As well as Priyanka Srivatsa's case. So both, my lord, while complying with section 154 subclass 1 and 154(3), my lord, there is clear gap of 7 days, my lord, before I take the next step. So therefore, that has been completely complied with.
I will look into it and ask.
Please.
Yes.
Lalit Kumar has been modified to 15 days to 6 weeks, my lord, not 7 days. ಇಲ್ಲ ಆಗಿಲ್ಲ ಅದಕ್ಕೆ.
Yes.
None of them, Your Lordship.
ರಂಗನಾಥ್,
Please.
Closing, Your Lordship.
ಹಾ ನಿಮಗೆ 5 minutes ಸಾಕು ಹೇಳಿ.
That's it. 12 points, Your Lordship.
12 points.
5 minutes will be done.
Yes.
They had mentioned that it was 23 years is what they had mentioned. That it took that long. Could have been done within one period of 5 years. The difficulty for them was there was a huge blunder. The blunder committed took 15 years now to undo,
Madam, 1 minute.
reboot.
1 minute. Blunder committed 15 years. Where were they in the picture in 15 years? Everything has happened on its own.
No,
They
no.
come into, you mean to say
They do
that, are you saying that the chief minister was of the idea, or the family of the chief minister idea of buying this land in 1997?
No, not at all.
No.
A4.
2004, the story commences from
It
this family.
doesn't commence from the date that the brother-in-law buys it.
Yes.
It commences from the date A4 applies, asking for denotification.
That
This
is
is,
Devraj.
yes, Devraj.
Devraj is an accused.
He's an accused. Now, what he does is, he works in the education department. He suppresses it. The whole scheme of all of this starts with a misrepresentation. He states, this is my only source of income. This is my agricultural income. And therefore, please denotify. Whereas he works here in the education department. It starts with that. And as I had taken your lordship through the periods when this was involved, it started from there. So from the period when Devraj had applied, it started. So what I'm trying to say is that 23 years is a fault of theirs, not ours, that they made a big blunder in the way they went about it. After finishing with denotification and then conversion, and then, oops, we've gone the wrong way. Maybe we need to take another route. And then applications start for compensatory sites. Now, the other issue that they seem to mention is that 50-50. It is not 50-50, reason being, in the Muda sale deeds to the wife of the petitioner, it states clearly that it's under the 1991 scheme. Now, the reason this is extremely important, Your Lordship, is that 60-40 allotment. If it is 60-40, say about in an acre, development 45% goes, 55% is only left. In 45 allotment, the parks, the roads, the amenities, all of that. 55% is left. In 55%, 40% of that is what a landowner is entitled to, which is be about 22%, which is about 9,500 square feet in 1 acre. 3 acres, let's assume for a minute that they have a flow of title, which they don't. 3 acres, they would have to get at best 28,000 square feet. What is given is on the 50-50 scheme,
Correct.
38,000 square feet.
Government had changed the scheme, by then 50-50 had come in.
The sale,
2015.
the sale deed itself talks of what scheme would be applicable to them. So the question of changing that would not arise. Your Lordship, as he had mentioned, I have to just make it very clear where Devanuru comes. That is this village that they're talking about. It's precisely 2 hours from Mysore, if we do it on the map. Now, if I have to draw a parallel, if a layout is being made, that is exactly the reason why I'm trying to state is that we need to say where Devanuru is. Devanuru is 2 hours distance from Mysore, if we take, say, Palace as the center point. If Your Lordship, there is a layout being developed, say, beyond Jigni, am I entitled to compensatory sites in Indranagar and choicest of ones and a sprinkling of all of them and 14 of them in Indranagar, I would not be entitled to? One of the defense taken earlier was that these are not incentive sites which have to be given in the very layout. They can be given anywhere, Your Lordship, because they're not incentive, they're compensatory. Compensation sites are always site for site. For example, if there's a flyover being made in the heart of town and they take my site, then they have to give it to me in the urban area and they can't compensate me with that. So if my area is being taken in Jayanagar, I can be given in Baswangudi or BTM equivalent value. I cannot be given something where I have own in Jigni and then I get in Indranagar. That is not possible. Your Lordship, next. The allegation is that, Your Lordship, that there are a lot of sanctions that are languishing, not met the light of the day, and this has been done in a tearing hurry. Your Lordship, all our brothers and sisters in the bar keep cursing us that we've taken up so much of Your Lordship's time over here for this matter. They can all say, where is the tearing hurry in this matter? This matter is not of any great importance. This matter could have waited. But Your Lordship, the point is ultimately,
I have granted an interim order. So that is the reason.
I'm just trying to say.
Are you
that
saying
this-
I should not take this?
No,
then?
exactly what, the contrary. I'm trying to state that they cannot say governor took this matter up while others are languishing.
You're drawing
So,
paraphrase.
drawing a parallel with what all my brothers and sisters have been cursing us with, but that cannot be done.
Oh,
It's the
are they so doing?
I'm sure they are, Your Lordship. So ultimately, it's the discretion of the governor. There could be other reasons for other matters, but that cannot be taken up now, right now to say that there are malifides in this and therefore it was taken up earlier. Your Lordship, the rights of they.
ಬೇರೆ illustration ಕೊಟ್ಟಿದ್ರೆ ಚೆನ್ನಾಗಿದೆ.
This is,
Yes.
the pressure is on by all of the others, Your Lordship. The CM's wife, they're stating that others were also allotted. Your Lordship, there is not one other case where allotment took
Is in
place
Vijayanagar.
in Vijayanagar area or any other well-developed area which is not in the heart of Mysore as opposed to being 2 hours away. Now, Your Lordship, even let's assume they're saying, okay, give us back our lands. 3 acres of lands worth 4 lakhs when it was sold. At best, it becomes 40 lakhs. Worst case, best case scenario, 3 crores. It does not go to up to 60 crores. That doesn't even happen in prime Bangalore area. And that could be the root of the ultimate problem. Your Lordship, then also going into the aspect of many others, denotification. Your Lordship, denotification can happen. There's land mafia everywhere. All of that denotification happens with whatever reasons. Can that be a reason that this, in terms of parity with other other frauds, this cannot be excluded. It's ultimately a public servant. Your Lordship, also with respect to the 262 and 264, Your Lordship, stating that 262, both in fact were owned by Ninga only. What happened
What
was
262?
sorry,
460.
462 and 464.
ಇದ್ಯಾವ್ದು ಹೊಸ ಸರ್ವೆ ನಂಬರ್ ಬಂದಿದೆ.
462 was also owned by the very same person, but he sold it to someone else. And this was what remaining for the three brothers ultimately. And flow of title doesn't happen. That's all.
Done?
Done, Your Lordship.
Yes.
Got the copy of the
Plan. Yes.
sanction plan. Learned colleague will show.
Sanction plan of that scheme,
The layout.
the
This-
layout.
This is the scheme
No,
that was
but
sanctioned.
where is this layout from? How far is this from Mysore? What Senior Counsel Lakshmangar said is correct? That it is 2 hours away from Mysore.
I don't know the details.
So yes.
Must be from
Then we'll
Bangalore,
get
my
to
lord.
know. Huh?
Must be from Bangalore.
I shall put it on the Google map right away and show, and then Shashi would have to buy us all signs.
Must be from Bangalore.
ಈಗ, there are two
Yes.
aspects to be noted from the plan. One is this survey number along with 462, both are marked as denotified lands.
In
and
the
they-
plan.
In the plan. And when the survey numbers are mentioned as to the details of the project, these two survey numbers are not in.
ಅದ ಮಾರ್ಕ್ ಮಾಡಿ.
ತೋರಿಸ್ಬಿಡಿ.
ಅಲ್ಲ ಮಾರ್ಕ್ ಮಾಡ್ಕೊಡಿ ಸರ್. ಪೆನ್ಸಿಲ್ ಅಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡ್ಕೊಡಿ. Oh, doesn't find a mention. Both 462 and 464?
Denotified ಅಂತಲೇ ತೋರಿಸಿದ್ದಾರೆ ಲೇಔಟ್ ಪ್ಲಾನ್ ಅಲ್ಲಿ.
ಆಯ್ತು ಕೊಡಿ.
So this is the layout plan that is executed and developed as.
On that basis, they want 50-50. Everything is there.
ಇಡಿ ಮೇಡಮ್.
I'm now
2
instructed.
hours ಸ್ವಲ್ಪ.
ಅಲ್ಲ, I'm now instructed to submit. Kesra is behind Columbia Asia in Mysore.
ಕೆಸರೆ ಗ್ರಾಮ. Then how can it be Devanur Badavane 2 hours from Mysore?
We checked both cases. We
Bangalore.
checked.
ಬೆಂಗಳೂರಿನಿಂದ ಅಂತ.
We'll see. We'll see, yes.
Hale Kesre is different. 40 kilometers, yes. What they are trying to put in is an Hale Kesru, which is near Columbia Asia. That's not the one. This is acquisition to us.
Anyway, Google will tell.
In the birds are,
Huh?
in the birds are creeping, chirping down.
ಯಾಕೆ ಹೋಗ್ಬೇಕು ಅಂತ.
Then I'll be the bellwether, Your Lordship. We'll all.
Yes. Anybody else, sir?
The painstaking hearing.
No. Don't worry about that. I should determine that. That's all right. If anybody have to say something, please tell. Because I'm not going to list this again. Yes. ಯಾರ್ದು? ಕೊಡಿ. ನಿಮ್ದು ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
By tomorrow, Your Lordship.
By tomorrow it should be
Please,
there. Yes.
please.
ನಿಮ್ದು ಕೊಟ್ಟಿದ್ದೀರಾ ಎಲ್ಲ? ನಿಮ್ದು ಹಾಕಿದ್ದೀರಾ? ಅದು ಕೊಟ್ಟಿದ್ದೀರಾ ಅಷ್ಟೇ ಅಲ್ವಾ? ಎಸ್ ಸರ್, ನಿಮ್ದು ಆಯ್ತಲ್ಲ? ಎವ್ರಿಬಡಿ ಡನ್?
Please.
I am also done.
We are deeply obliged.
Yes, sir.
Such a patient.
No, for today. I say DD, done for the day.
Survey number is given.
Yes, thank you all.
Grateful to.
My lords, if I can just make one mention, my lords.
6:00ವರೆಗೂ ಕಾಯ್ತಾ
Date
ಇದ್ದೀರಾ?
was given for. I'm sorry, my lords. Date was given for tomorrow, my lords, but the office is not moving the matter, my lords. So instructions may kindly be given, my lords.
ಯಾವ್ದು madam? ಆ list
This is
close
WP
ಆಗಿರುತ್ತೆ.
number 250.
Tomorrow,
now-
sir, 10:30 move ಮಾಡಿ, I'll take it at 2:30. List close ಆಗಿರುತ್ತೆ. How will you take it? Move it at 10:30
Please, my
tomorrow.
lords.
Vinod
Please,
Kumar,
it is
ನಿಮ್ದೇನು?
already listed for today.
My
my
lord,
lords.
serial number
Again, today to-
52, my lord.
ಎಲ್ಲ ಇವತ್ತು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದ್ದಿದ್ದ ಕೇಸ್ ಎಲ್ಲ ನಾಳೆಗೆ ರಿಪೀಟ್ ಆಗಿದೆ.
Oblige, my lord.
Bill number 61 is 2, my lord.
ಹಾ,
Settlement, the time may be fixed, my lord. The respondent.
parties are there.
Yes, my lord, they're here right now. It was
Huh?
listed today.
ನಾಳೆ ಲಿಸ್ಟ್ ಆಗೋಗಿದೆ.
My lord, the urgency that I cited yesterday was, my lord, the respondents don't, already decided.
What's the offense?
Lord, motor vehicle accident case was 338 in 220.
where the parties get them. Yes, I'll finish that and leave. All of you can leave.
Great.
Yes, yes. Yes. Parties are here, still waiting. Respondent yaru?
Respondents are the complainant and the victim, my lord. The petitioner is the accused.
But true, sir. Respondents counsel idara? Sir,
Interim order continue.
that will, that you need not mention, sir. Adralli, heard reserved interim order subsisting will continue till the disposal of the petition.
For respondent number 2 and 3, for 2 and 3, my lords. May permit me to file.
What's the offense, sir?
My lords, the
Who said-
offense is 279 and 338 of IPC, my lords.
229 and
279 and
338.
Yes.
Kodi.
Lordship, may
Madam,
permit me
idella
to file
teggidi.
vakalat
Give it,
for
give it. Give the settlement,
Yes, my lords.
madam. Madam. It is sign ಮಾಡಿಸ್ಕೊಂಡಿ, sir.
Great.
Where are they from?
My lord, the accused victim is from West Bengal, my lord.
Oh, ask him to go. No problem. Order, you sign the order sheet and go.
Please.
Please,
Please.
Settled, closed.
Great.
But you'll get the order only after a week.
Great.
Great, sir.
Because they were waiting, I took it.
Great.
I'm
Grateful.
grateful.
Obliged.
Berilla.
List number 2, serial. Ella. Thank you.